direction for affidavit. This is the order passed by the
Which hearing bench?
hearing bench are there, but until unless the directions are there, it cannot be termed as ready for hearing.
No, which
So-
is the hearing bench?
On a hearing bench, irrespective of classification, other Rai Chattopadhyay is there, other benches are there, so that I can
They
go.
are not the hearing bench.
No, this is not the hearing bench. I am only praying for direction for affidavit from your lordship. This is the regular bench
No,
of primary.
your submission that I will pass a direction for affidavits and thereafter release the matter for assignment.
Yes.
This cannot be. This cannot be. There is no hearing bench. If you have to hear the matter, this bench has been details mentioned. I will take it up.
Yes, my lord, kindly take it up. Here, pass
It's
the
a new motion.
new motion. Motion, the regular bench. I have regular bench.
So please don't make submissions after the direction is issued for affidavit that you release the matter for assignment to.
No. I shall pray for at least.
This is the bench having determination. Till I have
Yes.
determination, I will take it up.
Yes.
For inclusion of at contempt for the first time, my lord. Contempt.
Where is the order?
Order is not
Kindly place the order. Yes, sir.
My lord, the petitioner got appointment on the basis of written test and contempt application, in spite of the fact that relevant papers were given to the authorities. And as Honorable High Court pointed out, as such appointment was given late of 8 months. That apart, she did not get leave salary, did not get requisite paper on service book and other relevant papers from the authorities. That apart, appointed candidates of her year of 2010 are getting more salary than her. Peculiar thing cropped up. She took the examination for the post of primary school teacher in 2004. She was called to submit requisite papers. She did it before the authorities, but appointment was not given in spite of the fact that vacancies were existing. She is facing pathetic situation. And
Has she joined?
she is working, but she is getting less salary than that of the candidates of 2010.
Please, you have given.
Now, let the matter come under miscase from pension head. This matter is in the
Have
month.
you given notice?
Notice is given.
Give them.
My lord, may I call with
Miscase from pension head.
my lord, matter was mentioned before your lordship. My lord, pleasure was that to issue notice to the other side, my lord. My lord, I have served notice to the my lord, district primary school council, but so far as my government.
What
That
is
is
this
concerned.
matter?
My lord,
Transfer.
matter for my lord, matter is running in the list of 183 on 18th August 2026. Matter is not my lord for upgradation, my lord. Matter is not my lord. My
What
lord,
is the matter? Transfer.
no, my lord. My matter is my lord. Petitioner was my lord suspended since he was implicated in a
No.
criminal case, my lord.
18th August, this was coming. Report they have filed.
Lordship,
They have filed report.
no, my lord, nothing. My lord, I have to resume my duties, my lord.
Give them.
My lord, mentioning.
New motion has been.
My lord,
193 18th August ছিল দেখো
Kobya,
my lord, mentioning item 563, release dated 18th August.
My lord, 2021 hearing matter. My lord, urgency is that the petitioner first transferred from Nodia to my lord Kuchbihar Dinata, as he is a political leader, candidate of assembly election. Thereafter, my lord, what has happened? I have filed a writ application, and my lord, the authority did not permit the petitioner to join in the Dinata. Justice Gangobadhyay passed an order for joining, but did not get the adequate salary which he has entitled to get, my lord, for 5 years, my lord. My lord,
affidavits
yes, my lord, my lord, I have served, my lord. Again, I served notice upon the state.
hearing a date ওটাকে নিয়ে এসো
My lord,
Gratefully, your lord.
order ওদের খবর দিয়েছো বেঞ্চে কি হয়েছে হিয়ারিং বেঞ্চ করে যাবো হিয়ারিং বেঞ্চ করে what was the date within a period of January, ঠিক আছে, last. You have communicated this also?
Yes, sir, I have communicated. They are not compensated.
Yes.
My lord, matter is disposed of, and order is already passed by your lordship, but some correction is required.
Get about 95 years, my lord. My lord, as per your lordship direction, my lord, it is filed by the GI Murshidabad and exception also has been filed and also been served upon the state, my lord. Kindly, my lord.
What is the item number?
My lord, it was not in the list, my lord. The earlier occasion, they, in Tuesday, my lord, it was running in the list. After that, it has been disappeared from the list, my lord. That's why they-
Disappeared করবে কি করে?
Yeah,
হ্যাঁ। On Thursday it will appear. Hearing date it will appear. No need to give that.
here in the my lord.
It will again come up in the coming week. You take back this.
My lord, for correction, my lord, for matters.
Yes. Yes. Regarding
Regarding 2009 selection form. Salary age, 58, 57. Unless some paper is. In the meantime, they will declare as determined age of selection to be found. One and another is almost similar. Division may direct who comes the report and some do not consideration. But ultimately, the division may revert to file a repetition. In the production, we have filed the repetition. These two repetitions. All petition.
which district? Which district?
Same.
Hooghly.
Mention with notice.
Okay, 2009. Hooghly was there in the order that was passed by Justice Mantha.
No.
It is not that.
That in respect of this. Justice Mantha. Howrah, North 24 Pargana, South 24 Pargana, and Malda. There is no dispute in regard.
Oh. Mr. Misro, ঠিক আছে লিস্ট করো নোটিশ দিয়েছো
Yes, madam.
নোটিশ okay yes
My lord.
order is there
Yes.
দেখো অর্ডারটা আছে কিনা
Till Busan 2024 matter upon notice as not in the
affidavits filed
no
the reports have been called for
no new motion matter no.
24 new motion
My lord, I have also the similar thing.
yes
New motion.
Well, I mentioned
New motion.
item 563 of the list dated 18th of August. Well, this is item 563.
563 18th August
Not-
18th August is
No,
Tuesday
he-
pension
Well,
pension
the petitioner is the widow of the deceased teacher. He is not getting pension. That is
Or may I permit to mention extension of interim order, my lord. Interim order will expire on in the end of August 2026. The interim order will expire, my lord.
So,
It is interim.
Devnath Babu
I have sub notice upon the other side. Yes, sir.
ঠিক আছে ওই 27-28 তারিখের লিস্ট করবো নেক্সট উইকের লিস্ট
Much obliged.
My lord, I prefer
My lord,
total
order
of
is passed.
promotion.
Matter is disposed of, but some correction is required.
what is the
My lord,
correction
similar matter, my lord. Similar matter, my lord.
sir I will come to you কি করেছে কত মিস্টেক করেছে an what is the mistake
My lord,
what is the mistake
my lord, area আছে.
what is the mistake in the order In WPA 2104,
below correction short form. I have annexed the order also.
so list karo. Please carry the copy of the writ petition at the time when the matter will be taken up.
One hearing letter, the IBDL for the post of librarian in Malda district, my lord. The total post is, vacant post is 4. I am also the 4. 3 is appointed, but 4 is not appointed, only sent to the waiting list, my lord. Already, evidence are complete, almost hearing completed, due to the series of the one, thereafter suddenly send the determination, my lord. And paying for, including the list for the
Is the library?
like inclusion.
Library?
Primary matter with conduct.
Primary matter, pension?
The primary teachers and have completed DLA course. They want benefits from the date of completion of DLA course or ROPA.
ROPA?
2019. 13 ROPA.
Okay. Category. When did you complete that? Which is the session? DLA session? What is the session of the DLA? You don't know? Is it A category or DLA? Please.
My lord, for inclusion as new motion, my lord.
What is the matter? Pension?
My lord, pension.
Yes.
This is for inclusion, new motion, Your Lordship, can you debate whether Your Lordship is hearing us on the point that the job loser teachers of first SLST, whether they will get extension to join in the primary service or not? 27th is the date for Malda district. This is regard to not 24 Parganas. This is new motion. It will appear for the first day. I have sub notice also.
In that matter, they have filed their affidavits.
Yes, but here, my lord, the extension was granted by the DPSC itself. Now they are not extending further, my lord. And in that matter, my lord, extension was not granted. It was granted
by the order of the court that is extended.
Yes.
27th.
That matter is coming.
Your Lordship. May I permit to mention, my lord, one matter, my lord, transfer matter. It is running on the list yesterday, my lord, 241.
Not
it
now.
is non-prosecution matter.
Non-prosecution. Written instruction is there? A written instruction for non-prosecution?
Yes, my lord.
You produce that, to be mentioned.
My lord, with notice to my learned counterpart, my lord, I am mentioning, my lord, 5 matter, transfer matter. My lord, 7th of August, I have mentioned 2 matter for upgradation. Your Lordship, possibly Your Lordship allowed the prayer. However, it has, my lord, all are medical ground transfer. My lord, only Your Lordship says a usual order applied in the online or kindly, my lord, upgrade it. Great.
Your Lordship.
My lord, one new motion, my lord, and another, my lord, 2 transfer matter, your lord, it was running in the list, my lord, every Thursday, but yesterday it was not appeared.
Yesterday it will not appear.
And
It will appear on transfer day.
Yesterday was transfer date.
Give your sleep.
And interim order was.
Give that sleep.
Interim order was in the this month. Interim order granted to your lordship. This is the order.
কবে এক্সপায়ার হচ্ছে? এন্ড অফ অগস্ট, তাহলে নেক্সট কামিং উইকে রেখে দিই। Under the heading extension of interim order.
My lord,
New motion for pension. Pension.
Terminal benefit.
my lord, may I
Lordship,
permit-
may
Yes.
my lord, minor correction of the order dated 3rd August passed by your lordship.
Give the copy of the order.
Copy. Copy the.
How do we understand what is the mistake?
My lord, minor correction, my lord. Date of application appear. My lord, to be mentioned, kindly listed.
Give that. Without seeing the order, how can I ascertain what is the mistake and putting under to be mentioned? Yes.
Your Lordship, may I leave to mention, Your Lordship, this matter is appearing as item number 283 in today's list. The petitioner is not getting the home rent allowance since 2018.
280.
283.
Why?
Because she is living alone and she was separated from her husband. She has made many representation to the authority, but they are not releasing the house rent allowance to the petitioner.
What is the reason? Is the husband and separated means
That they are living separately.
they are living separately for their job, or they are living separately for
Separately for their
marital disputes? So the husband is working.
Yes, my husband is working.
Okay. 283. What is the name?
Chitra Dalal versus the state of West Bengal.
Take it.
WPA 9950. Notice, Your Lordship, I will inform in the course of the day to the other side.
Give.
Lord, Lordship. Lord, may I have?
My lord, may I permit to mention for correction of two orders of the lordship for possible part of.
No.
My lord, may I get your kind permission?
Go. Gautam Babu.
My lord, I am praying for your kind permission to make a mention, my lord. My lord, this particular matter appeared on 21/7/2026.
On 21st.
On 21st July 2026. According to this my lord's direction, this matter is supposed to appear after 2 weeks, but unfortunately it didn't, my lord.
This what matter? Transfer.
No, my lord, it's pension matter.
Okay.
Hmm.
Take your order. ঠিক আছে লিস্ট করুন
Lordship,
Grateful, my lord.
Lordship, may I permitted to mention one matter? It is listed motion for inclusion in the list, Lordship. It is for the appointment of the petitioner which has been withheld after the, in spite of the specific direction of the Honorable High Court.
listed motion of which year this is?
2024.
24. আচ্ছা এই যেটা কেটে বেরিয়ে গেছে এখান থেকে তার মধ্যে নাম্বার গুলো মিলিয়ে নিচ্ছেন তো মোশন যেগুলো 2000 এর বলছে দেখো আমাদের তোমার মান্থলি লিস্টে আছে কিনা দেখে নেবেন
No, listed.
Lord, may I? The matter. Your Lordship, can pray to look into the order. I have just xerox hurriedly.
Hurriedly?
Yes, I have to go down and they have to do top floor.
This is for?
Contempt application first time.
Lord, may I have your lordship kind leave me, Lord?
It
To
will appear.
mention these three matters, my lord, the petitioners, my lord, completed diploma in elementary exam education course. My lord, their course was completed in the month, and entire examination was completed in 30th June 2019. Result was published in last week of December 2019. The ROPA came, my lord, in July, if I am not wrong, 2019. So they did not get the benefit of ROPA. So because their result was published, so my case is that for the purpose of getting benefit of ROPA, they since they have passed the examination, the effect should be given from the date of completion of examination. This is the crux of dispute. Another thing is, my lord, there is another course conducted by the central government, that is 1.5 years diploma in elementary education course. The persons who joined in that course after them, they were passed out in the month of March. So, my lord, although they joined the course after them, they passed out in March, they got the benefits. They joined the course earlier to them, and completed the course prior to ROPA. But since the result came out thereafter, the effect of ROPA was not given. That is my sole contention. We have served the notice upon the learned advocate appearing for the respondent, my lord. Let it appear under the heading listed motion.
Three motions.
My lord, new motion, since these matters were tagged together, but Justice Abhijit Ganguly was, my lord, as my lord was then was pleased to direct my lord to withdraw the writ and to file fresh writ petitions according to the my lord each district. Thereafter, my lord, they took up the plea that another matter is
Separate mentioning slip for separate items.
then not, I will do it in the recess and I will give it to them, my lord. I'm great. But notice is one, my lord. One notice I have served through indicating three writ petitions. Indicated the three. I'm give it. I'm tiffin as a teacher.
But I mentioned for inclusion matter, motion matter.
For
motion. For pension matter.
Pension.
Yes, madam.
May I be permitted to mention this matter? Your lordship, recollect your lordship's memory. My lord, on 11th, it was appeared under the heading to be mentioned for withdrawal. CRR matter, my lord, criminal division.
Ramashish Mukherjee.
Yes, my lord.
Why didn't you appear on
My lord,
Wednesday?
yes. I rushed from the court number 550. That's why I could not reach.
No,
My lord, what happened to second day? It has been
it will
fixed.
appear on Wednesday. Wednesday they appear করছে তো
on second it will again appear. My lord, the difficulty is that I could not obtain the certified copy. I applied on 12th itself, 11th itself.
Okay.
My lord, as the file is not goes down, that's why I could not collect the certified
copy. Your requisition thereafter it will be sent. Let it appear on second. It will appear on
again,
second.
it will take time. My lord, the petitioner is the
No, I am not
bedridden
going.
condition. My lord, if the file is sent down and my lord, within one day I can
As soon
collect
as the requisition is received from the department, the file will go.
I have filed it on 11th August.
So they have to make a requisition. It will be sent accordingly. Let the matter appear on the date fixed on second.
Well, in the meantime, I cannot collect the certified copy. There is a direction to service upon the PP office. That's why.
Order দিয়েছি না? Requisition তো নেই। এসছে requisition কিছু?
I think requisition has been come because 11th is the I have filed it. Application on 12th it has been uploaded in the status of the case.
My lord, may I be
Give that slip. If
Yes,
the requisition is received, it will be sent.
Yes, my lord.
my lord, may I be allowed to mention three similar matter for upgradation for notional benefit, my lord. It's at 1027, 1028, and 1029 of today's list for notional benefit.
Notional benefit of 2017.
2019, my lord. 2009 recruitment process and 19 they were appointed, my lord.
One of 17 and the 21.
My lord,
These are the two. One is February. One is of 17. Notional benefit of 17 and there are 21. 19.
my lord, last
Notice দিয়েছে?
yes, my
আপডেট
lord,
এমনিতে লিস্টে নাও লিস্টে রয়েছে তাহলে দিয়ে দিন we'll take it up
but my lord, print
no
for
no not
upgradation.
My lord, may I permit to few matters of the upgradation matter, my lord. A category scale of pay, my lord. My lord, 14 matters are there, my lord. And
A category I have
my lord, kindly for upgradation, my lord, but
I'm taking it up on particular date on Monday.
my lord, but
Really will take it up. What is the?
but not
Yes, Mr. Mondo.
my lord, one matter, my lord, for inclusion, my lord.
No.
Apologies for bothering your lordship, my lord. I'm mentioning item number 144 of the today's list, my lord. The matter is urgent because of the fact that despite the suspension order was lifted due to the intervention of this honorable court, the respondent school authorities, my lord, are not paying the amount that has been granted to the petitioner. Petition is in hand in mouth situation, my lord. Item 142. I'm only.
Where is the order? Order passed by the court?
My passed in a previous writ petition, ma'am. Previous writ petition.
Where is that order?
I'm not, unfortunately,
No,
not
kindly, kind. Carry that order, show me that order, we'll see. Come in the next week with the order.
My lord, I shall.
Requisition না হলে তো পাঠাবার কোনো question নেই। যে ফেরত দিয়ে দেবে। এনাকে বলে দাও যে রিকুইজিশন এলে তাহলে পাঠাবে যদি আসে।
Appear for the respondent number 2 in this matter, Washimogo Shamogra Shikha Mission. Your Lordship, it has come up at the instance of the petitioners, Your Lordship, that mentioned this matter because the CAT 1 and 2.
When is the other matter appearing?
7th of September, Your Lordship. There's a list of 7 matters. It was taken up day before yesterday.
Yes, yes.
Your Lordship, the opposition is filed in those matters. This I would be praying leave to file opposition, Your Lordship, in CAN 3 and 4. Those matters are slightly different because opposition is already filed. They've been kept for hearing.
না একটা ক্যান তো উইথড্র করেছিল।
CAN 3 and 4 is, I believe, they listed on the list. It's appearing.
কোথায় ক্যান?
I don't know if it's filed or not. I'm not.
1 and 2. 1 and 2, 3 and 4.
1 and 2 are dismissed.
They withdrew.
They withdrew. 3 and 4 are the restoration and the condemnation for delay. I'll be filing my opposition to these applications.
Okay.
If leave may be granted for me to file my opposition, I'd be grateful.
You have got the copy of that?
I've received the copy on the 19th of August.
Matter is appearing under the heading to be mentioned. None appears on behalf of the petitioner or applicant. US. Mister, what is your name? Jayji Medhi, learned advocate for TV SSM, respond number 2, seeks to file affidavit in opposition to the applications being CAN 3 of 2026 and CAN 4 of 2026. Huh? তাহলে কি করে order হবে? 7 September is the date.
7 September are the list of 7 matters. The item 20 to 27 on the 19th of August.
আজকে ছেড়ে দাও। কেটে দিন। Not today. Let it come up on Monday because they have not received CAN 3 and 4. Put onion in. Next.
My lord, I'm for the petitioner. My lord, I'm sorry, my lord, I'm giving your lordship's travel, my lord. The only predicament your lordship on the basis of the submission of the council, the learned advocate of the council, your lordship directed the district inspector of school primary, since he is in the charge of the council, so directed him to consider the representation. Now, my lord, the council, my lord, the DI is saying, I am the, since the direction upon the DI, I am not your employee. I cannot do unless it is directed to respondent number 5, the chairman. Without application of mine, but my lord, I am in soup. If your lordship, instead of 4, my lord, if your lordship 3 instead of 3, it will be my lord 5.
Presentation. Okay. It will be 5.
Everything is clear from your lordship, my lord, on the basis of the submission. Your lordship
is appearing under the heading to be mentioned. Inadvertent typographical error has crept into order dated 9 July 2026 in paragraph number 7 in line page number 3, line number 2/3, mentioning the words respond number 3, District Inspector of Schools P, instead of which authority?
Malad Chairman.
Instead of
5.
Respondent number 5,
Chairman,
Chairman, District Primary School Council, South 24 Parganas. The words in paragraph number 7 at page 3 in line 2/3 be read as respondent number 5, Chairman, District Primary School Council, South 24 Parganas, instead in place of respondent number 3, District Inspector of Schools PE. The order is modified to the above extent.
And paragraph 9 also, Your Lordship.
9. 9 to 9 you. Line number 2 and 3. Yes.
Grateful, madam.
Yes. Good.
I think 4.
4.
Your Lordship's order dated 18th August 2025. A communication was made along with the server copy of the order duly received on 28th August 2025. Thereafter, reminder by forwarding letter dated 24th 11.
Issue notice 4 week. Start সপ্তাহ পর।
May I please, Your Lordship? Lordship, the petitioner participated in tender and work order was issued, completion certificate was given. My lord directed them to pay the contemner, the full amount. In spite of that, my lord, they have ignored. We have issued contempt notice, but they have ignored.
Order has been communicated.
Yes, Lordship, order
When is
has been
that?
communicated, duly communicated, my lord. On 10th November 2025, we have communicated the order. Page 20, my lord, annexure P2.
Notice, 4 week.
My lord, similar matter, my lord. Similar matter.
Who is the alleged contemptor? District Magistrate.
Lordship?
District Magistrate is the contemptor.
Yes, district magistrate.
Same order.
My lord, similar. Similar matter, my lord. Same contemner.
Same.
Grateful bill.
Lord, I am for the Milord. Got the instruction. I don't have a copy of the contempt application, but I have got the instruction, Milord.
This is the content
Milord,
of violation of Lordship's order. Can you see? একটা কপি আছে আমার কাছে
মামলা করার জন্য দিন তারপরে
আমি বলে দিই তারপর মনে হয় মানে can you see the order page 15 relevant page 18 paragraph 10 relevant page. In view of the above, the Director of School Education, Government of West Bengal, respondent number 2 herein is directed to take a decision with regard to the approval of the appointment of the petitioner as well as the admissible benefit upon proper verification and taking into considering the office order of the Chairman District Primary School Council, North 24 Parganas, dated 16th April 2025, within a period of 8 weeks from the date of the communication of this order. And that order was communicated
Yes, my
subsequently?
lord.
Your
But
lordship,
I've got the instruction.
The order date. When was the order for? 8 weeks?
Order was passed on 24th of March.
Huh.
It has been considered, my lord. It has been found that this Sri Ramakrishna Sishu Vidyapit, my lord, where the petitioner is claiming to be a teacher, my lord, is a purely government-aided school, my lord. Therefore, my lord, it does not have the power to appoint any teacher on its own choice or to act in any manner that contravenes the statutory provision. It was contended, my lord, that this school belonged to Ramakrishna Mission Belur Math. But we have sought for an report from them, and we have been intimated that this school does not have any affiliation to the Ramakrishna Mission Belur Math. It is purely a government-aided primary school, and the school also has intimated that there is no record of the attendance of the petitioner in the school's regular teachers' attendance history. Even his date of birth and date of joining, etc., is not in the record of this school, my lord. Therefore, my lord, question of my lord, appointment of the petitioner, approval of the appointment of the petitioner does not arise, my lord.
but this question was raised at the time of the main hearing of the writ petitions. This same question was raised. Now, my lord, page 89 of my writ petition, the page 89 of my writ petition, the DSC was present. Kindly see. In compliance with the order dated sessions of the Honorable Justice Hiranmoy Bhattacharya, a further hearing was held on 16th April 2025 at 1 p.m. in the chamber of the Chairman DPSC, not 24 organized, hearing the matter related to the Jagannath Pal. In the hearing, Jagannath Pal was present and represented by his advocate Sumon Saha, representative of the DSC, Srimati Santa Das, ADSC, DI, SI, head teacher of Sri Ramakrishna Sishu Vidyapit was present at the time of hearing. As per discussion in the hearing and considering the representation of Jagannath Pal, it was decided to consider the prayer of Jagannath Pal, who was appointed with effect from 1st June 1976 by the then Secretary of Sri Ramakrishna Sishu Vidyapit, which is valid, kindly see, which is valid at the material point of time as per Ramakrishna Mission GO dated 15 September 1975, and also decided to give admissible benefit of Jagannath Pal subject to the verification of the documents required for releasing the benefit admissibility as per the applicable prevailing rules. Therefore, all this authority was present at that material point of time. This question was never raised before the authority. Therefore, my lord, when your lordship passed this order, taking the account of this order passed by the chairman, not 24 for one district primary school council on 16th April 2025, and this order was passed in all prayer. Now, this point was never raised before any authority. Now, at this juncture, this point is raising. And when your lordship heard this matter on merit, this same point was raised. This is not the government, and he is working in some other school. This point was raised.
This is not under Belur Math.
This is not under Belur Math. It is a purely government-aided school.
And all these documents were
Lord,
produced
I
at the time of hearing.
Instructions. I can give my learned friend also a copy. Let him take an exception. I shall also file my affidavit, my lord.
The poor teacher is not getting any salary, nothing of the sort. And the order was passed on 16th April 2025. Head teacher, SI.
For the school to.
Sagarwala tried to understand. Come to page 67 of the writ petition.
I don't have, my lord, a copy.
You
I
don't have.
just engaged.
Okay, I just indicate to you.
Yes.
This is probably the third round of litigation.
Yes, my lord.
The first round of litigation, you will find an order at page 67 where it records that the appellants are working in Ramakrishna Vidyapit in primary section with effect from 1977. This is the order of the division bench, honorable division bench. And it also records of a GO of dated 15 September 1975, which was whether they will be considered as whether Ramakrishna Mission has the autonomy to appoint the teachers or not. That was also decided therein.
Yes.
You go through the records. I suppose
My learned friend, give me a copy.
this is reopening of the issue which has already been dealt with by the honorable division bench and the coordinate bench of this.
I've understood, my lord.
Yes.
Lord, can my learned friend
Yes,
give
I
me
will
a
keep.
copy so that I can
Give
take
that
a
copy.
appropriate instruction?
Miss Manju Agarwala, learned senior advocate, appearing for the Affidavit of service filed on behalf of the petitioner is taken on record. Ms. Manju Agarwal, learned advocate, Agarwala, learned advocate,
Instruction दिया.
senior advocate appearing for the alleged contemner, seeks accommodation to file. Ms. Agarwala, you take this back, file an
I'm taking-
affidavit of
yes, I-
compliance annexing and go through the documents
Yes,
in
yes,
there.
no, let me take appropriate
Yes.
instructions.
Seeks
Huh?
accommodation
Let
to
me
take
leave it, that's
proper
okay.
instruction and file affidavit
Affidavit is due.
of compliance. Let such affidavit of compliance be filed by the alleged contemner on the returnable date. List this matter on such and such. Mr. Dotto, you hand over the copy of all
Yes,
the
I am.
copies.
But today, in course of today, I will.
কবে কাকু বলো 2 সপ্তাহ পরে 2 weeks
For 3 weeks because I have to prepare
List
an
this matter
affidavit
after
take
3 weeks.
instruction.
11 September 11 September
Congratulations.
That matter, I am for the applicant. Your lot order dated 2nd May 2025, where your lordship directed to demolish the entire construction as it is illegally constructed and without building permit. Thereafter, challenging the said order, there is a appeal, which is page 32. The appeal court dismissed the appeal, affirm your lordship's order. Yes. Your lordship's order has page 22. Without building plan, without approval of the Panchayat authority, the construction was made, so your lordship directed to demolish. Challenging the state order, there is a appeal as page 32. Appeal court dismissed the appeal and affirm your lordship's order. Operative part is page 33. Thereafter, communication was made, page 34. And order has
Who is the
not
alleged
been
contemner?
fully complied. So
Alleged
there is
contemner?
reminder notice at page
Who is the
50.
alleged contemner? District engineer and Sabhadipati.
Howrah, Jila Police.
They were directed.
Yes, my lord.
They were directed. The alleged contemners were directed.
Direct the district engineer, my lord. Second reminder notice. I served at page 50.
It's order dated 34.
50.
Oh, cost of demolition.
Konusri Haldar, district engineer, Howrah Jila Parishad, and also Kaveri
Notice, 4
Sabhapati.
weeks.
Applied.
Attended my for the petitioner. This is a matter relates to notional increment. Petitioner got their appointment in the year 2022, page 33. Page 33, the letter of appointment. After
February
getting additional,
2017.
and it is the coordinate bench already passed an order, which is at page 36. No, page 39. কোনগুলো দিচ্ছ? হ্যাঁ, it is. 39, 42, all orders I have annexed. They are in she is entitled to get the notional income since February 2017.
Para 2 of page 39. These
39.
petitioners are similarly circumstanced.
Yes, because my lord, kindly see the list, page 32 once, page
No, no.
32.
This para, they are similarly
Absolutely, page 32 I have annexed the list also, wherein the name of the petitioners are featured, page 32. Sanjita Kormokar, serial number 1, 2, 3, 4, 5, 6, 7, 8. That's why I attached the list also. After getting additional 6 marks, they are entitled, they got their job.
Yes, Mr. Biswas.
What my last friend is like, he had the DLA prior to 2016. And that is why he was complaining, that is also challenge, but the basic difference is because 2016 onward BEd was not training qualification.
Prior to 2016.
Prior to 2016 even. My BEd was not the meant for the primary, settled my lord.
Yes.
And my lord, you see, my lord, only 2020 recruitment BS was considered because of the ACC notification. That was also subsequently passed by the Supreme Court. Now, my lord, he is not entitled to get. As an he joined, my lord, he is entitled. You also can see, my lord, training 20, 28, 29. Then it cannot be, my lord, considered as a 10 candidate.
Well, prior to 2016, she completed his BEd qualification.
Yes. Okay. DLA.
BEd.
BEd. So the pitting na to 10 deserve. What was the my lord, Sohom was that since the candidate of Sohom had the training qualification of DLA and he was not given appointment 2016, all the 10 candidates were appointed 2016 recruitment process. But Sohom had the training qualification of DLA. That is why court directed if he was given appointment at that point of time, he could have been given.
This is not the matter. This is not the matter relates to Soham Rai Chaudhary.
Yes, absolutely.
Kindly see page 25 once.
Yes, your lordship, kindly come to my lord.
Page 25 once, their own notification whereby the petitioners are called for verification. The crux of the matter, we are given appointment in the year 2022 in spite of 2017. They are appointed, they are given appointment to the petitioner.
The petitioner is not claiming A category scale of thing. Petitioner is not claiming A category scale of.
No, that's
notional.
Notional.
Malad, no, your lordship, notional. Malad, notional. Then Malad, he has to have the qualification at that point of time, recruitment of 2016. He must have the qualification.
They have given the appointment in favor of the petitioner. Now, my lord, in the year 2026, they are saying that. Their own notification, I participated in the verification process. Subsequently, a letter of appointment issued by the concerned district primary school council. At that point of time, they had not raised any objection regarding my qualification.
We have not. We cannot.
I am seeking, by filing the writ petition, I am seeking notional increment.
Because
they have no right to challenge my qualification. Then, my lord, first of all, at the time of verification, they had to object in respect of my qualification.
Lord,
after giving appointment.
When, my lord, the notification, your lordship, kindly see the date of notification, page 25.
15th February 2021.
2022.
Absolutely.
It is, my lord, recruitment process of 2020. My lord, where the BEd was permitted to appear in the recruitment process. So BEd was the qualification for the primary to be considered. My lord, he is asking now, my lord, appointment of 2016. My lord, if he is considered 2016 appointment, my lord, then he have the, my lord, should be the qualification of primary. My lord, 2016. My lord, he has only, my lord, BEd. My lord, he should have been, my lord, DLA. Unless he had the qualification of DLA, he could not be treated as 10 candidate and he should not be given appointment 2016. So, my lord, if my lord, he has not qualification of primary at that point of time, there is no question of his appointment.
So if the appointment, there is no question of appointment, he is not entitled to any notional benefit from 2016. When he was appointed as B.Ed candidate, training qualification considered to be as a primary qualification, then he is entitled to get appointment. 2000 on and from 2020 recruitment process, on and from February 2021 or 22.
In page 39,
Yes, your lord.
Soumitra Nemo, this
39.
person, yes.
Malad, this order, page 39, is relied by Malad, your lordship kindly turn to page 40. Page 40, Malad, the second paragraph, I am just reading. Learned Council appearing for the West Bengal Board of Primary Education submit an appeal has been prepared in case of similar situation. The man number such and such. The matter is pending before the division bench, though interim order is first delayed on inquiry from the court. Learned Council clearly submit that in case of also Soham Rai Chaudhuri has been granted all benefits. Malad, they have relied upon the Soham Rai Chaudhuri. Malad, Soham Rai Chaudhuri had the qualification of TLA, but he was given appointment in 2022. So court said, if he given the TET marks in the right time and he would qualify in the TET in 2016, then he must have given the appointment 2016. So he is entitled to notional benefit from 2016. But in this case, your lordship, kindly visualize, he cannot be given appointment in 2016 because of his qualification.
No, because of the
Because my lord, he was not the 10 candidate that automatically he should be given appointment.
But if the trained candidates are given,
yes,
after that you go to the untrained.
Yes. Yes.
So in that event,
my lord,
if we presume that in 2016, after exhausting the trained candidates, you have given appointment to the untrained. In that event, the petitioner will not be entitled for notional benefits.
I'm answering your lordship's query. I got your lordship. My lord, the ratio has been, my lord, decided in the Soham Rai Chaudhuri. My lord, Soham Rai Chaudhuri's case, because all these come from the Soham Rai Chaudhuri. All these, my lord, equity or my lord, what is the right? My lord, Soham Rai Chaudhuri's case was specific case that since I had the qualification prior 2016 DLA. So at first, all the 10 candidates, because the number of 10 candidates was 10,000 and odd. Vacancy was 42,949. So therefore, all 10 candidates initially given appointment. Whatever may be the my lord other. So my lord, considering this aspect, the court said, if you would have been given the pass the test at the right point of time without the fault of the board, then he should have been given appointment in 2016. So he is entitled the notional benefit on and from 2016 since he was a 10 candidate. But so far the untrained candidate, the 6 marks, 6 marks was given and subsequently division bench judgment it will be followed on and from the next recruitment process. I'll show you lordship. If you want to show your lordship judgment, I will show. That is why the untrained candidate for getting the notional benefit or A category, whatever, is not considered from 2016 recruitment process.
Okay.
Here, the case before your lordship, present case, the petitioner qualification was B.Ed. So he would have been passed TET in the right time. He was considered as the untrained candidate. Okay. And he joined in the service as a 10 candidate 2022. So therefore, there is no question to give him the notional benefit on from 2016 recruitment process. At best, he can ask the February 2021. Because bulk appointment was given 2021, February 2021.
Okay. You come up with a report.
May I give reply?
Let him file a report first.
Yes.
Let's see what is.
First of all, we appear.
Officer of the court asking your lordship from the
First of all, my lord.
Come from the state and the council. Though if your lordship
First of all,
file the report.
Petitioner appeared in the recruitment process of
Affidavit
2016.
Service filed on behalf of the petitioner is taken on record by the present writ petition. The petitioner seeks notional benefit from February 2017. Mr. Dibyendu Chatterjee, learned advocate for the petitioner, submits that pursuant to order passed by this coordinate bench of this honorable court, the petitioner who participated in the recruitment process of 2016 has been given appointment in the year 2022. The candidates, similarly circumstanced candidates have already been given notional benefits from February 2017. Granted notional benefit from February 2017. He seeks that similar benefit be extended to the petitioner. On the contrary, Mr. Ratul Viswas, learned advocate for representing the West Bengal Board of Primary Education, submits that the petitioner was given appointment as untrained candidate. Therefore, the petitioner cannot claim notional benefit of February 2017. Since on the date of his appointment, he did not possess the requisite training qualification, particularly diploma in elementary education within bracket insert DLED. He seeks to file a report. Let such report be filed by the board as well as the state. State who is representing the state? You? You also file your report and see. Within a period of 2 weeks, advance copy, 3 weeks for hearing and data document. Hearing list. Next.
Returnable
after 3 weeks.
After
2 weeks, they will file their report. You file your exception. It will appear under the heading hearing.
Well, last occasion it was appeared. I have filed all. Every service.
Okay. First time আসছে. Oh.
The council should have been made party because council is the employer.
On the prayer of learned advocate for the petitioner, leave is granted to which council?
That one council হবে.
Council
Should be Malad.
পশ্চিম ওরা না রঞ্জিতা হাওড়া
Howrah. Learned advocate for the petitioner ready to serve copy of the writ petition and its annexes upon DPSC. Added respondent number. What will be the number?
Respondent number 7. 7 and 8.
And file affidavit of service on the returnable deed. Getting a listed. তারপর তো 12টার সময় ডেকেছিলাম ওদেরকে 12টার সময় ডেকেছি
হ্যাঁ দিয়ে দেবো না আমাদের 11টা
After 3 weeks this will appear. You serve upon the DPSC and come back. 2 weeks you file your report, you as well as the state, and give a copy. You will file your exceptions. Yes.
11, your lordship, can you take it up next week?
No, 11 page 30. Kindly see page 30. I have attached the DLED qualification.
After this.
Yes.
Council party no 11. 11 is council party.
We are hijacking
Or
yes.
I have called you in respect of the last day's yesterday's hearing.
I could not hear what you
Yesterday's hearing,
Excellent.
which you are appearing through virtual.
Yes, my lord. That pursuing beard matter.
Yes. In that there are 2 CAN applications.
Yes, I know.
Ground.
I know.
But after due consideration, I thought that this is a part of the lead matter.
Yes.
At the same time, if it is released by this court,
yes,
then they would not get the opportunity to place their case before any of the forum because the lead matter is pending before this court.
Correct.
So I intend to permit the petitioner.
Yes.
Apart from the learned advocate.
Correct.
Apart from her, if any junior.
Yes.
If Miss Gopa Biswas or any of the junior intends to make his submission, his or her submission, so that we can conclude the rights of the parties will not be affected.
Absolutely.
And we can decide that. For that reason, I have called you.
My lord, this is lordship's compassion Had I been your lordship's place, probably I would not have been so kind, but this is
I think,
yes,
is
yes.
anybody,
Your
you're there?
lordship.
So we are placing the matter in
Yes, yes,
coming
I
week.
have.
You follow the list coming week. You make your submission with regard to can 4 and 5.
Correct.
Yesterday I said that I will release it, but I'm not releasing, permitting you to make your submission with regard to that so that we can conclude. Correct?
Well, absolutely.
Ask Ms. Gopa Biswas to come. She has not come today.
Your lordship, due to some difficulties.
Okay, you
No, no
intimate
requirement,
her.
because
She will there at
Submission.
Upanya.
Okay.
this order benefits, so
Your lordship, kind.
obliged.
This is the change only. Thank you.
Yes,
Much
my
obliged, your lordship.
lordship has this
I
journey of attaching and thereby detaching, because when lordship has to read the matter, there has to be some kind level of attachment, but fundamentally it has to be so detached. So
Thank you. Please come on then. তো আমি করে দেবো, আপনি পাঠিয়ে দিন, আমি করে দিচ্ছি। ওকে একটা অ্যাডজর্নমেন্ট দিয়ে দেবেন, এই লাইনটা করে দিন।
Item 11 for the petitioner. Kindly consider page 31. We have participated in the recruitment 2016.
নিবেন তোমাকে তো
Well,
কাউন্সিলে পার্টি করতেই হবে
একটু দাঁড়া,
Necessary
একটু
part.
দাঁড়া। I attach the order of the page 30 is the DLED qualification certificate of the petitioner, which is obtained 2012-2014. I attach the order of the matter passed in Shom Rai Chaudhary, which is at page 59. Shom Rai Chaudhary matter,
Your
page 59. 15, no, page, just a minute. Page 47. Page 47. The order speaks about giving chance to those candidates who, first of all, those candidates are declared unsuccessful in TET 2014 due to wrong additional 6 questions. Now what has happened? Subsequently, they in their 2021, they published a list of 738 candidates. In the list, name of the petitioner appeared. Petitioner got their appointment in the year 2022. They are seeking notional increment. Shom Rai Chaudhary matter. Shom Rai Chaudhary.
Your lordship has
What?
already decided it.
Shom Rai Chaudhary matter is not regarding the notional increment. Kindly see the order, page 47. May I read the whole order?
I have read the order.
My lord, he appeared into 2020 selection process.
2016 selection process. Let them file a report to that effect.
My
That
lord,
petitioner
he
appeared.
himself, he
Oh,
738 is my lord, the part of 2020 recruitment process. He appeared in
738.
2020 recruitment process.
738 is the notified, is not the notified vacant post of 2020 recruitment process.
Absolutely.
No,
what
absolutely
that
not.
is saying.
No. To 738 in respect of additional 6 question. Kindly see the notification once.
That's the part of
Yes,
2020.
again yes. Now he is saying yes.
My learned friend probably my lord is my lord, yes, I know my lord is my lord,
Page,
heavily, my lord,
page
saying-
25. Kindly see page 25 once. Page 25 once.
If you have participated in 2020,
2016 recruitment process, not 2020.
Mr. Chatterjee, will you allow the court to put the question?
Yes, 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 absolutely.
If you have participated in 2020, then you were not born in the cadre in 2016. So whatever will accrue after 2020. But if you participate in 2016 as per order of the court, then you can claim that 2022 has been given. So I go back to 2016.
Here, my lord, I have not participated
So
in
I am
2020
time and
recruitment
again
process.
asking you, page 44, whether you are similarly circumstanced as Soumitra Nemo. If you participate in subsequent 2020, then it starts from 2020.
No.
If you
I
do not participate and by the dint of the order of the court, you are getting appointment in
Absolutely.
in recruitment process of 2016.
16.
But joining in 2022, you get a notional benefit from 20.
Similar case of the
So he
petition.
says that 2020.
No.
A single scrap of paper, if my learned friend can show before your lordship.
Kindly
even
adjourn the
before
matter.
That he participated or filled up the form in 2016 recruitment process.
Kindly make it not today, my lord. My
Whatever
lord,
may be the cost imposed by my lord, I will pay personally.
my lord, kindly make it not today, my lord. Kindly let the matter be appear on Monday to be mentioned.
Monday, my lord, Sunday, any
Hey.
day, but I will take responsibility. What I am submitting.
Sunday তুই আসবি তো? I shall place before your lordship the interview call letter and
Take
participate.
it back. Not
Absolutely.
today.
I'm ready, man.
Not today.
Not today, my lord. Let the matter be taken up on coming Friday.
Coming Friday, then I call for a report. Why to wait for that?
Monday, let the matter be taken up Monday.
Monday, he says that
Under the same.
primarily you show.
Yes, absolutely.
If you are in Soumitra Nemo, same similarly circumstance, then we can pass that.
I will. Absolutely. একদম এখন চেক করবি চেক করে অবলেজ বেলা গেট শুট
Milord, I am for the petitioner, Milord.
Yes.
This is my affidavit service, and subsequently I have also effected service of the government. But this is a peculiar case. The name of the petitioner is Mohammad Abul Khair Mullah.
Yes.
But unfortunately, in the appointment letter, it has been shown as Abdul Khair Mullah. Appointment letter issued. I intended to join the post. I was not allowed to join the post on account of this particular mistake of carrying D in between B or U. Lordship, kindly.
So you have not checked page 31?
Page 31.
While signing the joining letter,
yes.
You have not checked that?
No. In the below portion I have said, no.
No, you have not checked that joining letter, no? Your name has been...
Joining letter, my lord, as it was in the appointment letter I have given, but in the below portion, Lordship kindly sees, I have signed as Mohammad Abul Khair Mullah.
Mohammad Abul Khair Mullah.
Abul Khair. Lordship kindly turn to page 23. Where from my lord will get it. Page 23. First, it is my admit card.
No, 28A.
Starting from, I am showing, my lord, page 23. Page 23. This is my educational testimonial. Secondary education, Mohammad Abul Khair Mullah, and father's name is Mohammad Hasim Ali Mullah. Then Lordship turn to page 24. This is my mark sheet. Mohammad Abul Khair Mullah. Father's name is Mohammad Hasim Ali Mullah. Then Lordship kindly the Madhyamik certificate. Page 25. Mohammad Abul Khair Mullah, Mohammad Hasim Ali Mullah. Then Lordship kindly the council certificate. Mohammad Abul Khair Mullah, Mohammad Hasim Ali Mullah. Therefore, my lord, mark sheet, HS mark sheet, same thing, my lord, Mohammad Abul Khair Mullah. And certificate page 28, my lord, same. And even in the application which I made for the post 28A, Lordship kindly sees Mohammad Abul Khair Mullah and son of late Hasim Ali Mullah. The application. Admit card, Lordship kindly see page 29. This mistake cropped up in the article 1, it was corrected by the authority. Lordship kindly candidate's name, the D was scored. Your Lordship kindly sees D was scored by the authority by signing there.
Yes.
But unfortunately, in the appointment letter, the same mistake D included.
Earlier there was a writ petition.
No.
So
What happened, my lord? This is a recruitment process of 2009.
Yes.
This process.
Which district?
District is South 24 Parganas. Ultimately, it got delayed for 15 years for various reasons, my lord. Ultimately, by court's order, this appointment process started from 24.
24. Yes.
24. That's why, my lord, I got it. I intended to join, I signed, and it was not done. Then I represented them. They are, my lord, delaying the matter. One authority says it has been referred to the school education, other says it is waited.
Okay.
My lord, the admit card, mark sheet.
You are appearing for?
State.
State. Yes. The council? Council who has corrected this admit card?
On behalf of council, none appear.
You have, sir?
Yes. Previous service Lordship kindly just I have served them.
Devnath Babu? South 24 Parganas কে নতুন এলো? Dip- Okay. Have you got any instruction regarding this? You have got the copy of the writ petition right now from Sharthak. Kindly come to page 29 of the writ petition. It says that there is a correction by the initial. This name has been corrected. All the documents also show Abul. Your appointment letter?
Appointment letter below page 30.
That
Here
na-
this,
No, name is not there.
my name is Mohammad Abdul. Here the
Oh, it's
D
Abdul again.
again. All the testimonials, same name, same address, same father's name. Only I have to wait for 15 years. I am on merit. I have appointment.
So you take instruction in coming week. I'm placing it on Friday. Why this anomaly has arisen? If it is can be corrected from your end, it should be corrected because this is an anomaly which will affect his future service. No, this has to be corrected.
I cannot even join, my lord. I cannot even join. They are not allowed me to join unless it is corrected. They are not allowed me. This is my case above. After 15 years, I have got on merit. I have gotten only for this spelling mistake, my lord.
Joining later, you have been allowed to join.
My lord,
8 February 2024.
no, I joined, but thereafter I am not allowed to join. I stated on oath that they say unless it is verified, unless it is corrected, they will not allow me to join. I could not join.
For 2 years, he is sitting tight over the issue.
No, not 2 years, my lord. Lordship kindly sees. After this, I am running from. I am made represented. They are saying it has been referred to the school education department. Now just
There is a writ petition. The petitioner seeks for correction of his name in the appointment letter issued in his favor. Appointment letter dated 6 February 2024. Issued in his favor by the chairman, District Primary School Council, South 24 Parganas, respondent number 7. Affidavit file করেছে, affidavit sir. Mr. Swensol, an advocate appearing for the petitioner, submits that the original name of the petitioner is Muhammad Abul Khair Molla, which is appearing in all the testimonials of the petitioner. The petitioner filled up his form for recruitment, stating his name as Muhammad Abul Khair Molla. However, at the time of issuance of the appointment letter, his name has been mentioned as Muhammad Abdul Khair Molla, for which reason the petitioner is unable to join the post as assistant teacher in the respective school. The petitioner has taken much endeavor for correction of his name. However, the same has not been corrected as yet. Hence this writ petition. Ms. Mary Dottul, an advocate appearing for DPSC South 24 Parganas, seeks accommodation to take proper instruction. DPSC South 24 Parganas respondent number such and such is directed to furnish a report on the returnable date. Release this matter 2 সপ্তাহ পর যে কোনো মানডেতে রেখে দাও, মানডেতে রাখো 7 September. 7 September.
Madam, for the petitioner, Madam, I have been served এটা কবে দিয়ে? After your lordship's last order calling for report, I have been given one report through WhatsApp on 14th August 2026, but the report dated 22nd April 2026. Your lordship copy দাও just a second. ওরা দিয়েছে? And that will go, my lord. Report subsequently. I take your losses. Just refreshing your memory, your losses. একই জিনিস। Now, your losses kindly consider this matter at page 21. Your lordships starts at page 21. Relevant page will be your lordships at page 22. I think that's not legible to your lordships. 22. Legible, your lordships.
Page 22.
Of the writ petition. The type copy is there.
The type copy is there.
Your lordships kindly. The type copy.
Yes.
Just now, in exercise of the powers given under section 107 of the Act of 1973, the governor is pleased to order that the aforesaid recruitment examination conducted by the district inspector of schools of North 24 Parganas, South 24 Parganas, Malda and Howrah be cancelled and direct the respective chairman of the concerned district primary school council to conduct the recruitment examination de novo, provided that only the eligible candidates who had applied for recruitment against the advertisement issued by the concerned district primary school council and had appeared in the written examination are allowed to appear in the de novo examination, and no separate fees are collected from them for appearing in such examination. No other candidates except those who were allowed to appear in the earlier written examination conducted for the same purpose will be allowed to appear in the de novo written examination, and the entire process must be completed and the final panel published by the respective division within a period of 90 days from the date of issue of this order. This was the order of 21st June 2012 of the Honorable Governor. This relates to in the selection process of 2009 and 10. Now, since we were eligible candidates and we applied for the recruitment process and we were called for interview, which was cancelled. We were again called for interview. Your losses will find those things. If your losses kindly consider. Just a minute, I'm giving you losses there. Your losses will find we were called for interview, we appeared. Now your losses will find page 24.
Yes.
Well, kindly see, the panels were approved. De novo examination was held in 2012, but the panel was not disclosed. But the government approved the panel and this was kept in the dark. This was not published. Last paragraphs, your lordships will find not the last paragraphs. The undersigned is to inform that panel showing the names 2560 candidates under different categories of such and such of the candidate such and such under such and such as prepared and submitted by the chairman North 24 Parganas in terms of the order dated 21st June 2012. That's one of the Honorable Governor's order of the state government as amended from time to time against the notified vacancies of 2560 post under different categories. I'm leaving the categories. Then the third line are hereby approved provisionally for 1 year. Elos is getting it. So panel approved, but the approved panel was not published. The petitioners moved this honorable court for we have given the examination. Please disclose the result and the panel because they didn't know. Now ultimately transpired before the court. By this order, the government published the panel, but the panel was not published. Now, what was the order of the learned single judge? Ultimately, your lordship. I have given a copy to your lordship. Do you? If not,
given.
Your lordship. Now, your lordship kindly come to paragraph 39 and 40. These two paragraphs at page 36. In the GO dated 21st June 2012, there was a categorical direction towards the publication of the panel. And after conducting the de novo examination within 90 days from the date of issuance of the said GO, the validity of the said GO having been upheld by this court, the respondents cannot evade their obligation to publish the panels. This government order, the governor's order was questioned before this honorable court by the other candidates or persons who appeared earlier. And they lost.
90 days, yes.
And they lost, Malam. That's why the court recorded that the GO have been upheld by this honorable court. Then paragraph 40. Accordingly, this court directs the North 24 Parganas DPSC and Malda DPSC to publish the panels as provisionally approved by 11th June 2025, as I placed before Lordship, page 24.
2015.
2015, sorry, Malan. Page 24 of the writ petition.
Why this is 11th June and 17th June?
Malad, there are, Malad, your losses will find 11th or oblique June, I think, my lord. The 11th June, probably there will be some signature somewhere, your lordships. I do not get it. No. Panel approval. The order 11th oblique 17th. No, that's okay. Joseph Janti Jaisen, 11th can.
Yes.
Probably
Paragraph 37. There were two dates of this panel. 7th and 5th.
But I believe, Malad, there are two districts probably.
Okay.
No, not probably.
Yes,
Two districts. That's why this was given. Now your lordships will find paragraph 40.
40.
Accordingly, this court directs the North 24 Parganas and Malda district to publish the panels as provisionally in their respective websites within a period of 2 weeks from the date of communication of the order. Vacancies arise every year due to retirement and resignation or removal or dismissal date of appointees. The 2001 rules provide for sanction of additional posts of primary teachers due to increase in roll strength in primary schools of the district or the subdivision. Having regard to the peculiar facts and circumstances that have emerged, and as the respondents are to be blamed for having denied appointment to the candidates empaneled, they must take necessary steps to ensure the empaneled candidates are appointed in the existing vacancies, and the respondents, including the state respondents, shall also take steps towards the creation of new posts to accommodate and appoint the empaneled candidates. The above exercise towards to be done shall be completed by the respondents, including, my lord, from the date of publication of the panel. Now, your losses, the one প্যারাগ্রাফে দেখিয়েছিলাম জসিম কি যে এটা বোর্ডের ফল্টে হয়েছে one of the paragraph. আমার বিপটা করে আসেন এখানে যে I will show you losses one paragraph. Here the court has come to the finding that I will just take your losses to that.
What is the contention?
Contention, the court held that this is the fault of the respondents because of
Para 41.
And that's 41.
It starts with having regard to the peculiar facts and circumstances that have emerged. And as the respondents are to be blamed for having denied.
That language I missed. I read before lawsuits. To be blamed for having denied upon. This is the very vital. Then your lawsuits kindly consider page 27. After this judgment was tested before this honorable court, before the honorable division. That's okay. Well, the matter went up to the Supreme Court at some stage. Thereafter, there was no appeal against this judgment. Page 27, your losses kindly consider. 5th January 2022, I was appointed. Well, the judgment delivered, my lord, on 22nd, 12, 2020. Justice Topabatu Chakraborty, my lord, now our respected, my honorable Chief Justice, 2020.
No,
Hearing
judgment is delivered
concluded.
on 8 January 2021.
2021. Now the appointment, your lordships will find even then, every stage, my lord, there is a delay. Contempt application has to be moved, then vacancy was created, supernumerary vacancy is given, and then appointment. I'm trying to show you, lordships, from 2009, in order to get a merit on the basis of merit, or your lordships 2012, de novo, your lordships proceed. 2012, we have to get 10 years to secure our appointment. We have to come before this court repeatedly and then we secured on the basis of appointment. And this is the appointment letter, page 27. And we joined 28. But the resultant effect are twofold, your lordships. Here, my lord, some offense, exception, demerit point is taken. The juror relationship is absent. So that's why, my lord, say individually they have moved. This is their service benefit. Individually they have come up. Now there are, your lordships will find there are two sets of relief. Someone is running short of qualified service, because unless they get 10 years qualified service, they can't. Somebody have been appointed at the age after 50 because of this. Because minimum age was 40, maximum age limit. If a general candidate gets 40 or the scheduled caste candidate 45, then if that's delayed by 45% age, who was at that point of time delayed by 10 years, if we add 10 years, when the appointment he gets 55. So he will not have the qualified service. This is one. Here, your lordships, the petitioner has got the qualified service. He will be getting rather at the retirement, but he will not get the full pension unless this 10 years or 12 years is added. So they have come up before your lordships for getting notional benefit. Well, kindly take your lordships defense, then I will take your lordships to the judgment. First, this has been filed by the state. Then তোমাদের কপি আমাকে একটা দেবে, তোমাদেরও দাও, যশোরকে দিয়ে দাও। না না, তোমাদের নতুন কিছু দিচ্ছ না একই?
I am appearing on behalf of the DPSC notice of file report.
But I have not yet seen it, but I will proceed before lordships. Kindly see the state first. 22nd April 2026. Probably this was given as an instruction. This is instruction, not the report, to the learned councils for the state. Kindly, after I'm skipping over your lordships the first paragraph. After initiation of 2009 recruitment process, multiple cases were filed before the Honorable High Court, Calcutta, on the Supreme Court also. Finally, the petitioners joined service on 11th January 2022. Appointment, as I placed before your lordships, 5th January. I joined 11th January. Pursuant to the Honorable High Court's order dated 8th January 2021. Being appointed, the petitioner claims notional benefits from the date of panel of approval, that is from June 17, 2025. Because you did not disclose the panel, kept it pending, kept in the drawer, and I lost all my service benefits. Had it been published even in 2015, probably we would not have come before your lordships. Even count from 2015, somebody losing service benefits for 8 years, 9 years. It's not a case, my lord, that the appointment was not required to be made. Suppose law is clear. Just because I am been impaneled, I doesn't have any indefeasible right to be appointed. We can address much on this because it's a very, very restrictive views. When the state comes up with an advertisement for public recruitment, unless they can show plausible grounds for not to recruit, then your lordship, it should be deemed that the requirement was there. That's the line of judgment. But that's an extreme case where the case made out and fought out. But normally not indivisible right, so that I have to go out of court. Now your lordships find, however, the petitioner's claim for notional benefits, including fixation of pay and incremental benefit from June 17, 2015, is untenable in law. I deal with one by one, all are legal submissions. Existing norms, service benefits, including seniority, pay fixation, incremental benefits are allowed from the date of appointment and not from the date of panel of approval. My lord, my submission answer to the facts itself. You kept the panel pending. Approved panel. Didn't publish. Court directed it that you should be blamed. Publish it immediately and appointment them. My lord, does it behove in the mouth of the respondents to come say for denial of the benefit, service benefit, that is from the date of appointment?
Panel was published on which date?
My lord, after the judgment, officially panel published.
8 January, after 8 January.
After
8 January, no? 20th January.
After 8 January.
After 8 January. But the panel approved, my lord. I'm aspiring to be appointed on the basis of merit. How do I know that even in spite of approval, you kept it pending? This was disclosed in the proceedings. Then, my lord, what is the my lord, concept of notional benefit? My submission would be, your lordships. Notionally appointment to be treated from the date I claim, if I can have a justifiable claim before your lordships. There might be different type of cases. Here, why we are asking from the date of approval of the panel?
Yes.
Because you kept it pending. You means you, the state, whosoever may be. There may be a change in the government, but the state is one. The state kept it pending. I cannot be blamed for it. I lost my side. Had I been appointed in 2015, I would not have lost the service benefits. So notional concept always, my lord, relates back to a particular date from which I lost the benefits for inaction on the part of you. It doesn't require actual appointment, in other words. Because I am not asking for your lordships area payments without working. Notional benefit does not entitle to me to area payment. Only fixation of pay. My lord, in Bengali called Jettana. I have to be appointed immediately on the date of the approval of panel or the very next day. And then, your lordships, my pay will be fixed notionally from that day. And this will be calculated like this. I will not be entitled to area. But on the day I actually join, that amount has to be calculated. What is the difference which actually paid and why actually I would have got. Then the difference will be paid from that date, not from the notional period. Clear to your lordships? This is the case, your lordships. Because your lordships administrative side often deals with this. In your lordships administrative side, often deals with it. So this is one of the peculiar argument on the part of the state. I'm not claiming actual benefit, but actual benefit difference from the date of my actual appointment, and rest the notional. The right to appointment. Mere empanelment does not confer a right to appointment. Well, does it behave after the judgment of the Justice Tapabrata Chakraborty? Then why did you appoint me? Why have you not made this statement? You have made, and that was rejected. But if you place the entire judgment, this point was raised. You cannot go like this. You have to show, my lord, if someone saying that, that's why initially I pointed out that judgment or galore on the point that mere empanelment does not give indefeasible right. They have not used the exact word. I am telling you, Lord, indefeasible right to be appointed. But when a petitioner comes up and says, for denial of appointment, unless you can show substantive and plausible reasons, acceptable reasons, then as a citizen and having appeared at the process, I have a right to be appointed. There are the line of judgments. But often government says, I take your losses to this extent, that the vacancy declared your losses 1,000. But after preparation of the panel, government finds that I don't require more than 500. They don't proceed further. But that will be an affidavit. And the court will decide it. Court has decided that because of you, this has happened. Then how could you say that mere empanelment is not a confer a right to appointment? And what I'm praying for, a right to appointment has been crystallized, my lord, because by virtue of the appointment. Point remains whether you delayed in appointment or not. This is my case, my lord. Then your lordship, no provision in law. The petitioner's claim for notice prior to appointment is beyond any provision of law. Well, that's your lordship, the law of equity. This is a common law. This is a common law, my lord. When there is no law, the common law applies. Because the law did not foresee that he will do it. Legislature did not foresee that an appointing authority will act like this. That's why there is no provision. Then precedent, your lordships. My lord, such and such similar matter regarding appointment clearly states. Kindly, I have a loss. This is, my lord, may I pray? The Honorable Justice such and such, Justice Mantha had order dated such and such in clubbed writ having similar matter regarding appointment of petitioners to 2000 recruitment clearly states. Kindly have a look at this. My lord, just because somebody to be, my lord, defeated or, my lord, to be argued, these sort of arguments are appointments shall be prospective, and petitioners shall not be entitled to claim area benefits before the date of appointment. Paragraph 7 quote, all such appointments shall be prospective and shall be issued and effective from today. I will show you lawsuit. The petitioner shall not be entitled to claim any areas. Well, kindly have a look at this judgment. Then I will make my submissions. See the, my lord, facts of this case. My lord, before placing this judgment, one facts I tell you, lawsuits. You were appointed before this judgment. Before this judgment, Justice Mantha's judgment, I also appear. And on the similar matter, I regularly probably appear before your lordships. We were appointed pursuant to the judgment of Justice Tapobrata Chakraborty. Now kindly see. By consent of the parties, matters are taken up for hearing, treating them as on day's list. The Commissioner of School Education has filed a report addressed to the AGP. So the report deals with the allegations such and such. The allegations of the petitioners are in respect of improprieties in the recruitment process of 2001, completed in the 2021. Completed means after Justice Chakraborty's judgment, they published the panel and started giving appointment, and that too after 1 year, 2022. The Commissioner of School Education has refuted the allegation, and the same is echoed by the chairman. What follows from the argument, kindly see, of all councils is that only candidates with a fixed percentage of marks in the academic qualification in the respective categories and subjects were allowed to sit in the written examination. Such written examination was followed by vivavocy and aptitude test. What also transpires from the submissions of the parties is that, pursuant to the order dated, several supernumerary additional posts have been created. This court at this stage does not wish to enter into the nomenclature of the post created. Suffice it to say that as many as 2605 posts were created by notification dated 21 issued by School Service Commissioner of School Education. The recruitment process is of the year 2009, which was completed by issuing appointments in the 2021. After taking into consideration the vacancies already existing, the new post created, it transpires to this report that the petitioners, there are about 800 posts still vacant. Was getting it? In a decision in a coordinate bench in respect of such and such. This judgment, copy. No. Howrah DPS. A consensus was achieved by all concerned parties that the writ petitioner DPSC concerned that the Commissioner of School Education to accommodate the petitioners in all petitions filed up to the March of 22 be appointed against available vacancies. The said consensus was based on an order of the coordinate bench such and such. It cannot be said that there are no irregularities or improprieties in the recruitment process to the post of assistant teacher of the year 2009 completed in 2021. This court does not wish to make any conclusive pronouncement thereon. In the event the irregularities are accepted, the entire process of recruitment is liable to be interfered with. This should cause prejudice to the candidates appointed. That means, my lord, we are already appointed, and working for 3 years. There is no way of segregating the lawful and unlawful appointments. In the above circumstances, following the order dated 9th April 2024, for the reasons stated therein, in respect of the district Howrah, this court, by consent of all parties, is inclined to direct that all candidates who are called for interview and shall be entitled to appointments against existing and future vacancies. All appointments for addition of parties are allowed. Not mark all the petitions, aptitude test, all that. After verification, the panel waitlisted candidates kept alive, vacancies to be made. Then, your lordships, paragraph 17, they have quoted. All such appointments, means, my lord, appointments by virtue of this order, all of such appointments shall be prospective against the 800 rest vacancies and shall be issued and effective from today. The petitioner shall not be entitled to claim any. They consented, my lord. We have not consented to that because this is the order by consent. Because, your lordship, I tell your lordships, even after de novo selection process, there are a number of petitions against these 4 councils that there are irregularities. But in the meantime, my lord, those petitions are not taken up, and the Justice Chakraborty, before Justice Honorable Chakraborty, the writ petition was disposed of with that, and they got the appointment with the that this was blamed by them. Had it been, my lord, disclosed the panel, this could have been solved long back. So this is confined to the appointments made under this order, not our order. Kindly see the language. All such appointments shall be prospective. Our appointment was not on scrutiny before the court, nor was it, my lord, then shall be issued and effective from today. The petitioner shall not be entitled to claim any arrears or benefit before the date of their appointment. This is not the case. So this citation, my lord, absolutely erroneous and misplaced. This cannot be. The other affidavit I show your lordships, then I no, your lordship, this is by the council. No. Due to pending of the several page 5, my lord, Roman 6, I'm sorry, my lord.
Yes.
Due to pending of several writ petition for non-publication of the panel and no issuance of the appointment letter in favor of the district primary school not published in the panel for appointment of the teachers. But I fail to understand what does it mean. Either sentence is incomplete or verb is not used. Something somewhere missing, my lord. Has not published or had not published. What would be, my lord? My lord, after the judgment of Justice Chakraborty, how can they say it, my lord? Can they say it? And they kindly have a look at the panel, your lordships. The panel was, my lord, the approval order, 15. Kindly have a look at page 15, my lord, and the approval order.
Page 20.
Page 24.
Yes.
Last 3 lines are hereby approved provisionally for 1 year, excepting the following candidates obtained by the men below are withheld. Well, that's different issue. Then, Malal, next, this approval of panel shall abide by the leave of the Honorable Division Bench in Malal, such and such judgment and the 2 writ petitions mentioned. Therefore, my lord, there was no rider that cases are pending, therefore approval cannot be given effect to. What they say, I'm giving approval provisionally for 1 year. Each approval is provisional, my lord, initially. But that approval will abide by the ultimate result. Now, your lordships, none of the petitions, when this was passed, was pending even ultimately. All these, my lord, disposed of in 2017. That's transpired before the Justice Chakraborty. Mechanically, they approached it.
What is the writ petition that was pending before the Honorable Division Bench?
Well, that was, my lord, I tell you, this one is withdrawn. Both were withdrawn.
Oh.
Both were withdrawn in 2017.
In Rafiqul Mondol and
Rafiqul Mondol and Mitu Naich.
So did not the division Honorable Division Bench did not have the occasion to decide any?
Nothing. Withdrawn.
Okay.
Now, my lord, probably their records were not updated. They recorded it.
একটা জিনিস বলে দিন, এইটা উইথড্র হয়ে যাবার পরেই এই যে তপব্রতরা যে অর্ডারটা পাস করলো, তপব্রতার অর্ডারটা এই পিটিশনটা তারপরে ফাইল হয়েছে।
Obviously, that was after withdrawal of this writ petition, this was filed. Our writ petition, my lord, which was disposed of by the Honorable Mr. Topobroto Chakraborty.
এই পিটিশনটা প্রথমে জাস্টিস অরিজিৎ ব্যানার্জি অর্ডার দিয়েছিল, প্যানেল পাবলিক করে দাও, সকলের জন্য।
সব ফ্যাক্টস বলা আছে।
In the order of the Honorable Mr. Justice Chakraborty, your losses will find all the details.
Okay.
So therefore, grounds at Roman 6 well, does not have any meaning, my lord. Now, provisional panel was approved in the 2005 by the committee. That ultimate panel was published. Well, can the state say so like this? Ultimate panel published. It was a duty to publish. Pursuant to the district school publish the panel. I say the chairman issued appointment letter. I say that as per existing norms, serving benefit are allowed from the date of appointment, not from the date of the. Now I will show your losses judgment. Okay. These are the things.
Are you sure that Rafiqul Mandal case was withdrawn?
There are two aspects. First, even if your loss is pending, approval was given. You could have appointed subject to the result. Now your losses. I just take it. No, just a minute. বারকোড তোদের কাছে বারকোড মানে জাস্ট 14 20510 2014. I just get it, my lord. I think that was dealt with by the that was
One was dismissed on 17th May 2017. The other was 23rd June 2017.
This is the default.
Now, in page 29 of Justice Chakraborty's judgment, in page 29,
yes, no, yes, exactly.
There is a reference, but it does not record that it was withdrawn.
Dismissed, that was actually happened. Dismissed for default or withdrawn.
না ডিসমিস আমার ডিসমিস as withdrawing হয়েছিল বা ডিসমিসেবল লিখেছে।
This was recorded like that.
আমি অর্ডারের কপিটাও চাইলে দিই।
Even your losses, this was dismissed.
হ্যাঁ হ্যাঁ 2014।
So, my lord, if your losses consider the order of approval, this was not, my lord, even if your losses read it subjectively, you could have appointed me because ultimately this was dismissed. Now visualize, suppose your losses, you did not appointment because of the pendency even after approval and ultimately found dismissed. I will be losing 2 years service in spite of approval of the panel, but I can take the appointment subject to that rider.
এখান থেকেও দিতে পারে 17 2017 থেকে।
It can be from 17 because it is stating that it is only thereafter live stood infused into the panel. That is all.
That's all, my lord. Now your losses, I just cite your losses, the judgment, my lord, 2-3 judgments on this. My lord, my basic contention, my lord, whenever, my lord, the concept of notional benefit is extended by the or accepted by the honorable court, that's, my lord, the notion appointment is always to be notionally treated from that particular day. Actual appointment is different. I'm not asking for actual appointment. Actual appointment you have given, but for notional benefit, my lord, that order, your losses we have taken out, that 14 order. Your losses, can you take it up, my lord? একটু দর্শককে দিন, তাতে দিন। Can we look at this? Not only they have dismissed as non-prosecution.
Dismissed as non-prosecution.
We are saying from memory withdrawn, but like that, my lord.
20510
অন্তরা প্রসিড করতে চাইছে না।
First paragraph, third line.
20510. The other one?
Your losses in the both 2014.
No, one is 30510 of 2014.
Yes.
This is of Rafiqul.
Very good.
The other one is of
Mitunite.
Mitunite, is 30744. There is no reference of that?
Yes, yes.
Three zero.
আরেকটার নাম্বার কি? Well, we'll give that one also, Malad. They both Malad recorded. This was scrutinized. আচ্ছা এটা দে। আচ্ছা এই জাজমেন্টের কপি দিয়েছি জসেফকে?
না আমি দিয়ে দিচ্ছি
না তা আমি কিসের থেকে?
এইটা হ্যাঁ এইটা ফটো এনেছি
Malad, I'm citing this judgment, Malad, to explain the Malad the what is the notional benefit, Malad. Kindly see, Malad. This mandamus appeal and the application for Malad skip over up to Malad paragraph 5 or 6, then 9, Malad. Immediately after the delay in filing the appeal is condoned, we are requested by the learned advocates appearing for the parties to dispose of the appeal on merit by dispensing with the requirements of the filing paper book. We find that the papers which are necessary for disposal of the are before us. Then paragraph 10, finding the necessary already before us. Then paragraph 11. By the impugned order, the learned single judge of this court directed the concerned department to condone the deficiency of the qualifying service of 2 months and 1 day in favor of the writ petitioner to allow to get pension in terms of such and such. The entire exercise was directed to be completed within a period of 6 weeks from the date of communication of the two order. Malad, as I submitted before also at the initially, that there are two types of cases: shortage of qualified service and do not get the full pension. Or, Malad, I'm getting suppose 11 years qualified service. I would have got Malad 18 years. So I'm losing 7 years benefit. Even at the end of my service. Other fixation, all that. Mr. Bhattacharya, learned advocate appearing for the appellant, submits that in order to be eligible for pension, an employee should complete at least 10 years of qualifying service under Rule 8 of the said rule. She submits that admittedly, the writ petitioner failed to satisfy the said condition. As such, the writ petitioner, according to Mr. Bhattacharya, is not entitled to pension. She further submits that as per the note appended to Rule 7E4, the deficiency period can be condoned with a view to make up the minimum prescribed qualifying service for the purpose of death gratuity or family pension. Kindly see that what submission the state made. It is further provided that in other cases, power should be restricted to the employee's drawing pay not exceeding 4 to 5 per month at the time of retirement on invalid or compensation pension. He will never be getting the actual pension according to the state submission. By drawing our attention to the said rules, he submits that the deficiency of service is not condonable by the concerned authority if it does not satisfy any of the conditions mentioned in the note appended in Rule 5. He thus submits that since none of the candidates as mentioned in the note appended in the authority refused to condone such deficiency of service of the petitioner, he thus tried to justify the action of the concerned authority by relying upon the said rule. Let us now consider as to how far the concerned authority was justified in doing so in the facts of the present case. Here is the case. We find that the writ petitioner, along with several other similarly affected persons, moved a writ petition earlier before this court, complaining the concerned authority illegally denied giving appointment to the petitioner therein. Pause here for a moment. Before Justice Chakraborty, it was our case. Our de novo selection process as per the Honorable Governor's order concluded. Within 1 year, they have to, within a month probably, Your Lordship, they have to conclude it. But years have gone by, but they have not done it. The said writ petition was registered, disposed of by the learned single judge of this court with the following directions. In view of the pronouncement by this court in the aforesaid appeal on the basis of the judgment of the learned single judge, I grant similar benefits to the petitioner by directing the respondents to appoint the petitioner as primary teacher against the available vacancies within a period of 3 months from date. The said order was passed on 13th March 1991. The time limit which was fixed for giving appointment to the petitioner's hearing expired on June 12, 1991. Despite the state respondent was represented by its counsel, while the said writ petition was heard and the order was passed in their presence, appointment order was not given to the petitioner hearing till 1999. It is only on 28 June 1999 appointment order was issued to the petitioner during the pendency of a contempt proceedings. Thus, 8 years after passing of the said order, the writ petitioner was ultimately allowed to join the service. He thus lost 8 years of his service for no fault of his own. Kindly see, Malad, I will show another judgment of our honorable single bench. Achi copy. The concerned authority now, by taking advantage of their own wrong, cannot penalize the petitioner by refusing to grant pension to the petitioner on the ground of deficiency of 2 months and 1 day service of the petitioner. We thus hold this is a fit case where the deficiency of 2 months, 1 day service of the petitioner should have been condoned by the concerned authority. Let us pause here for a moment. This is perception of law. One has to perceive. Here, appointment letter bears a particular date. If your lordships instill my learned friend's argument into that, deficiency cannot be condoned. But the court says, Honorable Court Division Bench says, this is for your fault he lost this period. You have to give him. Now, I'm putting a question to myself. In this case, what will be the date of appointment, my lord, in the pension service book? Already recorded, my lord, the date, actual date. But at the time of calculating my pension, the rest period, the lost period has to be counted. So this has to be noted in the service book. This is, my lord, this is the notional benefit. This is the concept of notional benefit. And this is the common law. When the law does not deal with, the court comes up for rescue of the citizen. This is the judgment. Then your losses kindly consider. Oh, this is another matter, your losses. Change page number 4. Just other matter.
এখানেই তো অরিল ব্যানার্জি বলে দিয়েছিল আমরা পরের পাতাটা there was no order given to the panel not to be on the basis chairman are directed to take necessary steps for issuing appointment letter to the impanel candidate according to
another I think to how we have been dealt with. The teachers are always dealt with like slaves, my lord. Absolutely. Kindly look at page 6 of the judgment of the internal page 6 of the judgment of the Honorable Division Bench. Justice Tapobrata Chakraborty, my lord. Just for a moment. How many times the petitioners, my lord, were forced to come up before this Honorable Court? Internal page 6, my lord, last 8 line. The WPA number 1 and WPA number 2, that was marked. Your losses will get it, the actual petition number in the first page, were disposed of by a common order dated 19 July 2017, observing the life of a panel does not commence until its publication. The order of the approval of panel in this matter first surfaced. In this matter. Then ultimately culminated in the judgment of justice. And that provisional approval of the panel by the memo dated 17 June 2015, exact date, would not mean that the life of the panel started on 17 June 2015. Since it was reported to his lordship that the writ petitions referred to in the panel approving the order of the deputy director was dismissed and there was no order restraining effect being given to the panel, the not to know were directed to take necessary steps for issuing the appointments letter to the panel candidate in accordance with law and then disposed of by the honor. This was disposed of by common order dated 7 September 2017. This writ petition, which was ultimately disposed of justice by the judgment of Justice Chakraborty. This writ petition initial order was there. What happened, your losses? I am not taking your losses. Appeal was preferred. They lost. Then they went before the
appeal was
just let him just
after this order the council and the government both appeal was preferred before the division bench. Division bench formulating 14 points and remanded the matter to the
single bench since there was no direction for exchange of affidavit. Depend. Against that order, we preferred an SLP to the Supreme Court. Supreme Court, quashed all the set aside all this 14 formulated points and remanded back to the single bench with this only one point that whether the panel was published or not, that has to be decided by the single bench. And that is after remanded order of the Supreme Court, the order of Justice Tababrata Chakraborty was.
And that was not appealed against. So this was the history of losses. Kindly see how the time was lost and we were deprived. Well, I am taking your losses to the other judgments. Ar kono judgment আমরা দেখো দেখি দাও judge but kindly see the another judgment of our of the Honorable Justice Hiranmoy Bhattacharya. Just now, kindly paragraph 2 your losses.
Yes.
The very first 3 lines your losses, kindly go through. Your losses will get it qualifying service. Because 10 years, don't get. Then your losses, paragraph 3, prayer for condonation of shortfall. Then entire argument recorded. Then paragraph 7. Record reveals the petitioner had to approach this court to sit for the examination in connection with selection appointment. Pursuant to the order, application form was issued. Thereafter, the petitioner sat for examination 2009. After the panel published, the petitioner found that although he was successful in the recruitment process initiated by the council, he was not selected. The writ petition was initially moved on 2010. Well, therefore, 2 writ petitions already filed. When the writ petition came up for fight, it was submitted by the learned advocate for the council that in fact had been selected, but his name had not been forwarded for approval to the director. The said writ petition directing the director to take appropriate steps. The petitioner ultimately appointed. Now, kindly see how everyone secures their appointment, admitting he was selected, but that name was not forwarded. Maybe mistake, maybe negligence, but a selected candidate suffered loss. Then your lordships, kindly see paragraph 8. The right of the petitioner to be appointed to the post of primary school teacher, however, got crystallized when a decision was taken to forward the name of the petitioner to the director of school education for approval. Such delay is solely attributable to the conduct of the respondent authorities, and it ultimately led to the shortfall of the qualifying service for the pensionary benefit. Malad, I just explained, Malad, demonstrate my arguments. Panel approved in 2015. As soon as you approve the panel, Malad, by the strength of this judgment, my right crystallized for appointment. This is the Malad ratio. But I had to secure my appointment by filing writ petition and getting the panel published. Approved panel is always there. Published and the appointment 2022. And by this process, I lost 7 to 8 years. 15 to 22. So my right crystallized on the day when you approved the panel. Then your losses, my lord. The single judge dealt with. My lord, paragraph 9. Kindly see. Last 2 lines, my lord. After statutory flavor. No mandamus can. It is equally well settled that the petitioner should not be penalized for the lack of promptness in taking action by the concerned authorities. Then your losses ultimately, the writ petition, so many judgments were considered notionally when. Now your losses, kindly see paragraph 11. Another judgment was cited. I'm just read it out. This court has already held the delay in appointing the petitioner is solely attributable to the conduct of the respondent authorities. By applying the proposition of the law laid down in Suman Mondal, this court is of the considered view the date on which the decision is taken to forward the name of the petitioner before the director of school education shall be treated as the date of appointment notionally. Paragraph 11. kindly see the date of taken to forward the name before the shall be treated. Forward the name for approval. Therefore, my right crystallized. My right crystallized when you approve the panel. Therefore, kindly see the concept of notionally. Appointment notionally only for the purpose of completion. Here, my lord, only for the purpose of fixation of my benefit by reliefs different. Paid for different. Only my lord, fixation of benefit and then from a date difference and the consequential service benefits.
It was sometimes prior to 17 June 2015, the Director of School Education was forwarded, the DPSC forwarded it to the Director of School Education. Prior to 17 June 2015. The forwarding for approval from the Director of School Education.
In our case?
Yes,
Yes,
is
ma'am.
prior to 17 June.
Exactly, exactly. And 2015 this was granted because, my lord, because of the governor's order that was already flouted. That was already flouted. My lord, kindly consider the governor's order and that was taken care of by the judgment of the Honorable Justice Chakraborty. Paragraph. Within a period of 90 days, page 22A.
Yes.
So now if you, my lord, count from 12 June 1990, it ends, my lord, June, July, August, September, October. And that was finally approved the panel in 2015, June.
After the approval comes, the DPSC has to publish that panel.
Exactly.
Give the appointment.
Okay.
Ultimately, this is one thing, my lord. Therefore, my lord, this is the law, my lord, the notionally to be treated from that and fixation of pay and seniority. 1996 টা কোথায় গেল? Lord, kindly see this is the judgment of the Honorable Supreme Court. 1996 8 SCC page 637. একটু দিন। মানে facts মানে cannot be equal but similar facts, your lordships. When this is in case of promotion, but appointment. Promotion is also an appointment, my lord. Now, very short judgment. I will just place it, your lordship. Paragraph গুলো বলে দেবো শুধু অতক্ষণ দেখে লাভ নেই। May I read out, your lordships? The fifth respondent, Ramanandan, was selected by direct recruitment in the year 1977 for selection as assistant executive engineer. All the direct recruits except the respondent were appointed in the year 1978. It was admitted when he had filed original petition 7226 of 1985 in CAT, Ernakulam bench. By order dated 31st January 1990, it was held that the appointment was delayed due to laches on the part of the railway administration. This, kindly take note of this. After his appointment in the 1981, within 2 years, he passed his test. When his case was not considered for promotion of executive engineer, he filed the OA. The tribunal, without deciding the interstate seniority in the cadre of assistant executive engineers, had directed railway administration to consider his case for promotion as executive engineer for the years 1984, 1985, 1986. And if found fit for promotion in any of the posts, to give him promotion for that year and to fix seniority among executive engineers accordingly. Pursuant thereto, the respondent were considered and promoted as executive engineer. After the above order came to be made, the railway administration did not carry the matter in appeal to this court. Some of the persons seemingly aggrieved against the direction admittedly filed a review petition, which was also dismissed, and that order became final. The petitioners thereafter challenged the self-same order by filing separate way, and the impugned order of the tribunal dated 19th October 1995, the tribunal has confirmed its earlier order, and thus the special leave petition. It is contended by the learned counsel for the petitioners that since the inter-se seniority as assistant engineers was left open in the order, the direction given by the tribunal to consider the case as executive engineer and determine his seniority on the basis of promotion is not valid in law. We find no force in the contention. Once he is found to be eligible according to the rules, then his seniority is required to be determined as per procedure prescribed in the rules in vogue. He further contended that the fifth respondent was not qualified since he had not completed 8 years of required service. The tribunal has recorded a finding that 2 years period is relaxable in the case of the reserved candidates. The inter-se seniority as assistant executive engineer is required to be determined. He joined service in 1981. Therefore, he did not have the requisite service. We find no force in the contention. Since was selected by direct recruitment, he is entitled to be appointed according to rule. His appointment was delayed for no fault of his, and he came to be appointed in 1981. He is therefore to be entitled to the ranking given in the select list and appointed made accordingly. The same thing, my lord, ultimately. Because ultimate appointment was delayed in the post of assistant engineer. Therefore, relief was given. This is also a concept of notional benefit. Okay. My lord, these principles have been followed. My lord, only, my lord, this judgment, this is another judgment of the Honorable Division Bench. My lord, 2019 SCC online, Calcutta 9103, only paragraph 11. In that view of the matter, we set aside the order of the tribunal impugned in the writ petition and direct the principal secretary to reconsider the claim of the petitioner and to ascertain whether his appointment was delayed for no fault attributable to him or not. In the event the fault is not attributable to him, but the delay in appointing the petitioner occasioned only because official inaction and or negligence, the principal secretary shall proceed to take an informed decision in the light of the decision of Paresh Chandra Bhatt as well as the observation to take the claim to its logical end as early as possible, but not later. Malad, here, Malad, that point is no longer a sin trigger because Justice Chakraborty also held, Malad, delay attributable to the state. So the notional benefit, Malad, given here also. Malad, another judgment I am citing, Malad, of the Honorable Justice Rai Chattopadhyay. Ekটু দিন, yes. And নিয়ে নাও এটা WPA 268 এনে এটা দিয়ে না কপি নাও এবার শেয়ার করে নিও The very short point involved in this petition is if the petitioner would be eligible to be granted notional benefit for the period beyond her appointment.
Which paragraph?
Kindly see the very first paragraph, the issue decided in the judgment. Paragraph number 1.
Yes.
The very first and the very short point involved in this petition is if the petitioner would be eligible to be granted notional period benefit for the period beyond her appointment, which they say I am not entitled to. The fact remains that the court has found that the writ petitioner not being selected pursuant to the selection of 2009, which has culminated into the appointment of other candidates in 2010 as illegal, the petitioner claim is based on the verdict of the court. All that, your lordships. Paragraph 3. The action of, in bold letter, the action of the authority in denying the appointment is illegal, contrary to the provisions of the rules. Chairman of the directed to recommend the name of the petitioner to the for approval to the appointment. This order was passed on 3rd July 2012 and 10th August 2012 and 10th August 2022 in the writ petitions. Your losses, kindly see paragraph 4, Malad. This is their my lord claim. Then your lordships, paragraph 7. A selection process, paragraph 7, my lord, I read out. A selection process undertaken for appointment in 2009. The petitioner appeared in 2010. However, she was not found eligible. The other impanel candidates were appointed. He had prompted the writ petitioner to file case. The court's verdict, pursuant to the same, he was given appointment in 2013. The petitioner joined service in 27th February. Now, kindly see, therefore he lost, my lord, at least 3 years of service. Paragraph 7. Then your lordships, after joining the service, the petitioner filed this petition to claim the notional benefit. Paragraph 9. Admittedly, the petitioner has been in the service. She founded her claim on the declaration of its judgment dated such as that action of the authorities in denying appointment is illegal and contrary to statutory rules. She says that her right to claim notional benefits with effect from the period 12th April is invitarate due to reason of denial of her appointment being illegal and contrary to rules. It is a fact that the action is denying appointment declared illegal and that being contrary to the statutory rules. As a matter of fact, on this ground and to mitigate the the petitioner has been appointed subsequently. No doubt an illegal action is a nullity in the law and honest as if the same was never there. Since failure of to appoint the petitioner has been found to be illegal and deals the rules, the same should be considered as a phenomena which was never there. As the essential corollary, the present petitioner would be found to have been appointed with them. Kindly say would be. All are notional, my lord. And then your lordships, judgment, my lord, cited notional benefit in respect of Supreme Court judgment was cited, Lakshmi now such and such. This ratio squarely applies to the case. In the same, the court was pleased to hold that the appellants before it would be entitled to the notional benefit, including seniority, however, without actual salary. Kindly see here, actual salary we can't because we have not worked for that period. But the consequential effect will come on.
Calculation will be drawn.
Exactly.
And from the date of appointment, you get the money.
And the refixation will be done from the actual.
And length of service will get back to notional.
And that's my humble prayer.
My lord একটা judgment আছে আমরা ছিলাম রেসপন্ডেন্টে হেরে গেছি
No, no, that is
জজ স্যার দিয়ে দিয়েছে ম্যান্ডেটরি ডিরেকশন
2019.
Well, at item 14, 15, 16, same DPSC, same issue, 3 writ petitions because I have separated it below 10 years, below 20 years and above.
Copy not served.
My lord, it has been served. My lord, if this submission is being made, my lord, I am not here. My lord, if this submission is being made, copy not served, my lord, with all due respect, my lord, I will file. What I am only praying since my lord, my learned senior has submitted, issue is same. My lord, if your lordship keeps a day, I will make my submission only, my lord. One or 2 points.
কপি দেয়নি আবার
কি কপি
ওদেরটা আলাদা আমাদেরটা
আরে কপি আপনারা জিপি অফিস থেকে নিয়ে নিন তাহলে তাহলে এতদিন জিপি সার্ভিস করে ইটস নট মাই ফল্ট
These are my humble submissions, my lord. Okay. Let them conclude it, your lord. Because I have not.
আসুন তো এটা একটা অর্ডার করি report filed by the state respondents is taken on record, copy served. The report in the form of affidavit filed by respond number 5, chairman in charge, District Primary School Council, North 24 Parganas is also taken on record, copy served. It is submitted on behalf of the petitioner that the petitioner will not file any exception to the, you are not filing any exception to the report.
No, that legal submissions.
So I'm recording that. Not an exception to the.
But that doesn't mean that I'm admitting the contents of
No, no,
it.
no, you will not be filing. Required করে দাও. Submitted that it is not required to file any exception to the reports. But Mr. Subir Sannal, a senior advocate appearing for the petitioner, concludes his argument due to positive time, hearing could not be concluded. List it on Monday. Monday to আসবে না on next Friday. Copy রেখেন। What is your submission?
Matter, my lord.
All served, my lord.
All will come up Friday.
All served, my
ঠিক
lord.
আছে?
Let them
Next
take
Friday
it
তো
from short of, my lord. These are voluminous petition.
এটা না।
Saving. No, next Friday. What are reply?
My lord,
I will come back to you. Just wait. Yes, what is your item number?
14, 15, 16. Your lordship has fixed it
Serially.
yes, my lord. Next Friday, my lord.
My lord, we have also, my lord,
Yes.
my lord, 398 petitions.
Again, another is there.
My lord, if your lordship dispose it of the same order, my lord, is similar.
No, we
In
will.
one day, my lord, it will be disposed of by a single.
Can you wait for the order?
Yes, my lord. Let it be on Friday. I am not making the submissions.
Or Friday they রেখে দাও।
14, 15, 16, Friday.
I can direct you to start the form. Otherwise, my lord.
আরে একটা কপি দিয়ে না কেন ঝামেলা করিস?
Why are you not taking instruction from the office of the government leader?
In
This
June, it
because
has been
sometimes they are serving in the office. It is informed that assignments are being made from the office of the GP. Now again you come and say that it has not been served. They will make a photocopy of that, hand over to you. You can do it.
Yes, my lord.
Serve the copy. চলো 14, 15, 16 টা ফ্রাইডেতেই রাখবেন ওর সাথে। Yes, Miss বিশ্বাস.
yes, my lord. My lord, I have,
Yesterday-
my lord, learned, my lord, that my lord will
Yes.
take up the matter, my lord. Except 25, my lord, I have no difficulties. Next week.
I will give a date on
Yes.
27th or on next Monday.
Yes, your
Huh? You make your submission with
Yeah,
regard to
in
4
this
and
matter, my lord, the my lord, senior advocate, my lord, Obrutosh Majumdar will appear, my lord.
whosoever. You can also do
Yes,
it or
yes, my
Mr.
lord. My lord, already briefed. I have give brief to him, my lord.
4 and 5. That's why I called you. Okay.
Gratefully, lordship.
Oh. So Dasgupta, yesterday I was hearing a matter.
Yes, my lord.
I said 4 and 5 I will release, but I thought it right. Yeah, okay. Now 4 and 5 I will hear. Thereafter you file your replies and whatever.
Grateful.
Sure.
Item 3, my lord, I appear on behalf of the petitioner.
There is content.
The last occasion, your lordship was pleased to direct to file the compliance report to the alleged containment.
The process for compliance was initiated. That has been concluded. This is my conclusion.
And it is-
Page 34 is the last.
Kindly ask my learned friends to serve a copy of the complaint.
Where is the order? Which page is the order?
Page 34. And prior to that, the resolution starts at page 30.
Where is the order of this court in this contempt application?
Application orders are available.
19th August was inspection. Page 32.
34 is the without sanction, the building was constructed, has been constructed, and the Panchayat has given the occupier to demolish it within 2 weeks, 2 months. Otherwise, the Panchayat will take steps for demolition.
No.
Yes, Mr. Chatterjee.
Yes, my lord.
What is your submission?
But so far as the conclusion part is concerned, they are saying that they will take the action within 2 months. But in that case, if they have not, a fresh cause of action will arise. That is the difficulty. Most of the cases, the authorities, mainly the panchayat or the municipality, they are merely passing the order, the paper order. In most of the cases, they have not complied their own order.
Yes.
At this stage, my lord was pleased to direct the Pradhan to consider the representation regarding that has been considered, and this resolution has been taken. It was prior to issuance of this letter. It was discussed in the board of members at page 30, and the relevant portion starts from page 31. Elaborately discussed, and thereafter this has been
issued. It has been sent to post, my.
So far as my allegation is,
Why 2 months time has been given?
but
If there are some occupants and there are materials they paid for some time, therefore
matter was filed in the year of 2024.
there,
Why 2 months time has been given?
there are some materials inside the room that should be removed by the, they paid for some time.
2 months time was given to the panchayat to complete such exercise.
No, Panchayat, my lord, the representation has been considered. Now this decision has been taken that it is unauthorized and it should be demolished.
23(5) does not speak of giving an opportunity for self-demolition. It says that the permission granting authority, if it finds that there is illegality, to refer the matter to the SDO. That is the only option left. Now the SDO will issue a notice for hearing, and if it finds that there is some illegality, then they will demolish.
No,
After 2 months, the SDO will forward it to the SDO.
It has been sent to the SDO and BDO also.
Where is that? So why you have given 2 months time to the party who has taken illegal construction? There is no such provision in Panchayat Act that you will be, first of all, you will give an opportunity for self-demolition and thereafter the order will be executed.
Page 33 is the resolution.
The order was passed 19th August 2025.
Then
they have not complied with your lordship's directions. I was consent to file the instant contempt application. In the contempt proceedings, the panchayat came before your lordship, and now they are saying
you have find that there is illegality, you take appropriate steps under 23(5). Refer the matter to the SDO. Let him hear out the parties and pass an order.
That has been referred to the.
In each and every case, the petitioner.
The reference has been made to what? The copy of the resolution has been forwarded. Then
now the SDO will.
You give your findings. SDO, what we will do? In your resolution, you have given 2 months time. Now SDO will also sit for 2 months till the self demolition is undertaken, and thereafter he will issue notice to the parties if it is. Law does not authorize the Pradhan or Panchayat to give 2 months, 6 months time that you self demolish. It says that if there is illegality, refer the matter to the SDO. Within 2 months, the SDO will pass order. Pass a fresh resolution. Take a fresh resolution for referring the matter to the SDO in terms of section 23.
That is the law.
File a further compliance report. Affidavit of compliance filed on behalf of the respondent number 6, alleged contempt is taken on record. Mr. So-and-so, learned advocate, Atanu Vishwas, learned advocate appearing for the alleged contemner, submits that order in the form of a resolution has already been passed, giving 2 months time to the respondent to demolish the illegal construction, failing which the local Gram Panchayat shall take appropriate steps. Copy of the resolution have also been sent to the block development officer concerned and the subdivisional officer also.
Yes. Subdivision officer.
As well as the subdivisional officer. As per the order dated 19th August 2025, the alleged contemner was directed to take the proceedings to its logical conclusion in terms of provisions of Section 23 of the West Bengal Panchayat Act 1973 on the basis of materials transpiring during inspection and hearing. As per the para, the compliance report reveals that there is illegal construction, unauthorized construction undertaken by the private respondents. The provisions of Section 23 does not provide for giving opportunity of self-demolition. For better appreciation, Section 23(5) is reproduced hereunder. Upon bare perusal set out. Upon bare perusal of the above, the provisions provide that the permission granting authority shall refer the matter to the subdivisional officer concerned, who, after giving the owner of such building an opportunity of being heard, make an order directing for demolition of the building or portion of the building, as the case may be. Therefore, the period of 2 months given to the private respondents for self-demolition is dehors the provisions. The alleged contemner is directed to adopt a fresh resolution within the returnable date and file a further compliance report on the returnable date. Bolun 2 weeks for this matter after 2 weeks. After 2 weeks, within such period, take the resolution.
My lord, item number 17, Mr. Turunjoti Tiwari is appearing for the petitioner. My lord, Mr. Turunjoti Tiwari is appearing for the petitioner. My lord, I'm praying for not today, my lord.
What is your prayer?
My lord, I'm not brief in this matter, my lord.
Mr. Chaudhary, what is the case? Set aside the suspension order date.
My lord, may I? My lord, Mr. Torunjoti Tiwari is appearing in this matter, my lord. Actually, on
case.
Yeah, the case is, my lord, a FIR was lodged against me while I was in service. I was in custody, suspended. Subsequently, I released on bail. I got released and applied for rejoining. No steps has been taken yet. Yes.
DPSC Nudia, you have served?
Yes, my lord. Service. Service, yes, my lord. Service has been done. Further, on the new panel, upcoming of new panel, my lord, I have served again upon the state.
On behalf of the petitioner to file affidavit of service. 2 weeks for it up.
Deeply obliged.
DPSC Nudia, no? DPSC Nudia.
DPSC Nudia, yes, my lord.
2 সপ্তাহ পর Next.
At 18, my lord, I appear for the petitioner. But the report.
My lord, I am filing report, your lordship. Sir, serving the copy to My lord, in para number 1, line number 2, there is a typographical mistake, your lordship, that date is 5th September 2020, but instead of 2020 is written, your lordship.
5th October, 5th September,
5th October, your lordship.
October 2022,
2020.
20, 21st November, September 2020. Okay, that is as per data of option. 21st September. Happy to say violate data.
এতে কোনো পাওয়ারই নেই, সেক্রেটারি পাওয়ার আছে। ডিআই কি করে সেক্রেটারি?
Yes, what is your submission?
Mr. Pumalik is appearing for the DPSC matter.
Change of option. Change the date of option. But petitioner intends to change the date of option under ROPA 2019 matter. But the petition in the online portal matter, the date of option automatically which was shown as 1st January 2016 matter. Therefore, the petitioner had no opportunity to change the option or to elect the option date of option as per his own choice matter. But admittedly matter, in terms of paragraph 5 second proviso matter, provided for that in case where an employee has been placed in a higher pay band or higher grade pay by way of promotion or upgradation as per provisions of ROPA 2009 or as per government decision between 1st day of January 2016 and 25th September 2019 may elect to switch over to the revised pay structure from the date of such upgradation or promotion as the case may be. In this case, my lord, the petitioner was placed in a higher grade pay, my lord, between that cutoff period, and that has been that would be reflected from the service book of the petitioner, which is page 41, my lord, 11 portion. My lord, his grade pay was upgraded from 2600 to 3600. Therefore, my lord, the petitioner is, my lord, the entirely comes under the second proviso. My lord, he is entitled to switch over the option date of option from the date with effect from which the upgradation was allowed. That is the with effect from 1st August 2019, my lord. As per the government decision notification on the last occasion, my lord, I have handed over one notification dated 26 July 2019, whereby, my lord, the state had taken a policy decision to enhance the grade pay of trained primary teachers from 2600 to 3600. But on the last occasion,
yes,
my lord, the page 41, my lord, my service book, my lord. But the incumbent is allowed to enjoy enhanced grade pay from 2600 pay band to rupees 3600 in pay. VDA geo number 510 AC, that is the which I have just handed over to my lord, and his fixed is initial stage of pay 3600 and with effect from 1st August 2019. Therefore, my lord, in terms of the second proviso of Rule 5 of ROPA 2019, my lord, the petitioner may elect to change the option with effect from the date when such enhanced grade pay was allowed. That is, my lord, 1st August 2019.
The second proviso is at page 22, rule 5, second proviso. Admittedly, my lord, my grade pay was enhanced. As per the government decision. It is also government decision.
This is the notification which you have given is in respect of ROPA 2009 or 19.
But it is in terms of 2009, since, my lord, the ROPA came into effect with effect from, my lord, 13 December 2019. Page 21 is the ROPA rules, my lord. It starts from page 21 that the ROPA financial effect has come into effect from 1st January in 2020, and the notification was issued with effect from 13 December 2019.
Okay.
But the proviso also says, my lord, as per the government notification, government decisions. As per provision of ROPA 2009 or as per government decision? Great. Provided further that in case of where an employee has been placed in a higher grade pay band or higher grade pay by way of promotion or upgradation. Here, my lord, by upgradation as per provisions of ROPA 2009 or as per the government decision between 1st day of January 2016 or 25th September 2019. My lord, since they have calculated my pay scale as if I have exercised my option with effect from 1st January 2016, my the pay band has been reduced to, my lord, that I have stated from 31,000 page 5, my lord, paragraph 8, which was initially calculated as 31,600 as on 1st August 2019 after exercising option under ROPA. Subsequently, that was recast and my basic pay was reduced to 27,100 as on, my lord, 1st January 2016 by treating the date of option as 1st January 2016. Therefore, my lord, the pay scale, my lord, I am incurring loss every month, my lord. And the in terms of rule 16 also, my lord, the rule 17, if there any dispute, my lord, the secretary school education department is the competent authority for final decision, my lord. The secretary is the competent authority of the school education, and admittedly under rule 5, my lord, the second proviso, my lord, I am entitled to choose the or elect the date of option, my lord, the as per with effect from the date when the enhanced grade pay or upgraded grade pay was allowed.
Okay. Yes.
My lord, the petitioner joined in the said post on 19th June 2010, your lordship, and subsequently transferred to Netaji Subhas Primary School under Registrar Circle on 5th October 2020. Petitioner opted to come under ROPA 2019, your lordship, on 21st September 2020, and his pay was fixed at 30,700 as per his date of option on 21st September 2020, your lordship. And your lordship, the petitioner violated the date of option as per the ROPA 2000. Petitioner violated the date of the option as per the ROPA 2019 by notification number such and such, and clause 6.4, which states that options once exercised shall be final, your lordship.
And what about clause 5? Proviso to clause 5.
যেটা বলবেন এইটা।
Where is your option from annexure 2?
Well, page 91. আচ্ছা আচ্ছা না না 1921 এর আগে সার্ভিস বুকের আগে মানে পেজ 31 মানে October for 1st January 2016.
It's a manual. It's a manual form which has been signed by your client.
Yes, but
why do you say that automatically it is taking 1st
but
January?
kindly see, my lord, at the top, my lord.
You would have raised this issue, clause 5, on the date you exercise the option. It is manual. It's not that whatever date you give, it will take 1st January 2016.
But yes,
because manually she has put her signature.
but it was the form, but the when a cyclostyle form was issued, and I've only signed it, my lord.
No, Mr. Bose. আসুন। The report filed by the state is taken on record. By the present writ petition, the petitioner, last order, 2.
But may I place one decision of the Honorable Division Bench, my lord? But the Honorable Division Bench has interpreted Rule 5, my lord, and held that if it is there is a my lord, the increase in the grade pay, my lord, then the Rule 5 can be, my lord, the 5 provides a 2, my lord, the can be invoked, my lord.
আসুন। বলুন। Petitioner contains that that she is an assistant teacher. Which school?
Parada.
Assistant teacher of Netaji Subhas Primary School under
Initially,
Vishnu Circle.
Netaji Subhas Primary School under Ishra Circle.
On 21st September 2020, petitioner submitted option under ROPA 2019 under annexure Roman 2 of I-OSMS. Which paragraph you have stated of this option being given on the date of option?
But the paragraph 7.
Para. Follow. The date of option stored as 1st January 2016. In top. In the system generated option form of the petitioner, the date of option showed as 1st January 2016. And therefore the petitioner did not get opportunity to elect the date of the revised pay structure as per her own choice. due to electing the revised pay structure as 1st January 2016 in terms of system generated option form, the petitioner has been incurring huge financial loss every month. On which date you filed your made a representation on 5th June 2023.
এটা তো অপশন তো
2023 before the chairman of the DPSC Hooghly. Chairman DPSC
21st
Hooghly.
September 2020.
This is the first representation, 2023?
Yes, ma'am. It is first representation. Ma'am.
However, such grievance of the petitioner was turned down by the concerned authority, stating that there was no provision in IOSMS portal to rectify the date of option from the council's end. Where is that order of the council?
My lord, page 50.
আমি 5th June বললাম? Being agreed by and dissatisfied with such action of the respondent authorities, the petitioner has preferred the present writ petition. আচ্ছা ওনার setting aside চেয়েছে ওটার ওই মেমোটার মেমো নাম্বার 16 DPSC Hooghly dated 2nd April 2024. Mr. Onindo Bose, para 3. Mr. Swansol, learned advocate. Mr. Birijendra Pratap Singh, learned advocate for the state, submits that once an option has been exercised, the same is final and cannot be changed as per clause 6(4) of the ROPA rules 2019. Mr. Swansol, learned advocate appearing for the DPSC Hooghly. What is your name?
My name is Biman Khan. Led by Mr. Bosu Mullik.
Where is he?
He's engaged on photo number 25.
এটা ফোরটা বলবে না রিপোর্ট গুলো বলে দিয়েছিলাম না upon hearing হ্যাঁ রিপোর্টটা বলেছে না সাবমিট করেছে Upon hearing the learned advocates for respective parties, the only issue which calls for consideration is whether the council chairperson Hooghly District Primary School Council was justified in rejecting the prayer of the petitioner to change the date of option in respect of ROPA 2019. The petitioner has made categorical contention that since the date of option of 1st January 2016 was system generated option, Therefore, the petitioner did not get any opportunity to elect the date of revised fee structure as per her own choice. On perusal of the I-O SMS form of option submitted by the petitioner in annexure Roman 2 within bracket annexure P5, it is found that the petitioner herself has submitted such form after putting her signature. Therefore, to contain that the date of option, that is 1st January 2016, is system generated, does not stand to reason. The memorandum dated 13th December 2019 of ROPA 2019, particularly clause 6(4), clearly provides that the option once exercised shall be final. Accordingly, in view of the above, according to that one, in the above conspicuous, the prayer of the petitioner falls short of merit. Sorry, dismissed. You can say.
Lordship, I am appearing for the petitioner in this matter. Lordship, I have filed a contempt.
My lord, I appear on behalf of the alleged contempt. My lord, the communication I received from this is my communication. Kindly share with me. I will. My lord, they initiate the contempt proceeding. Later on, subsequently, my lord, they added an application praying to release 26 lakh odd amount. My lord, upon vetting and upon calculation, we found it is not 26 lakhs, but 1 lakh extra, 27 lakh. We approved that. We completed that entire process. We sent the matter to the Kolkata police. Now Kolkata police will pay that.
When? What is the time frame?
My lord, since Kolkata police is not an alleged contempt now, my lord. If
Sir, I'm asking you, what is the time frame? With the alleged contempt, add him as an alleged contempt.
that instruction, my lord, 90% problem, I think they are solved. Now it is
Okay.
actual payment, which has to
It
be
is
paid by the Kolkata.
informed by
The time bound direction.
learned advocate for the alleged contemner. You give a copy to her.
My lord, I will give that copy.
Lordship, may I just, Lordship, may I just make one prayer, Your Lordship? If Lordship kindly makes the direction time bound and Lordship kindly keeps the application pending.
Application and the contempt application will be kept pending. And I record his
grateful.
submissions. He says 2 weeks.
My lord, 3 weeks. And my lord,
The
3
3 weeks, this will be listed. You have got the copy. He says that for placement of fund, they have written it to the Commissioner of Police. This has been from the first land acquisition collector.
And Lordship kindly directs them to serve a copy of this document upon us.
It is
My lord, only one prayer. My lord, I direct the Commissioner of Police, Calcutta Police, to expedite the process.
No. That will come after 3 weeks. Since you say that placement of funds have been made, this document I am taking on record.
Proposal to the
Let us see what happens after 3 weeks. Since he has written to the commission, it is he is duty bound to do that. Yes. Contemner that the first land acquisition collector, the alleged contemner has already written to the Commissioner of Police, Kolkata Police, by its letter dated 21st August 2026 for placement of fund amounting to rupees 27,48,527 towards payment of compensation in compliance of direction of this court passed in order and judgment dated 15 January 2025 in WPO 349 of 2019. He seeks 3 weeks accommodation so that in the meantime the order of this court can be complied with. He files a copy of the letter dated 21st August 2026 of the first land acquisition collector, Kolkata, the alleged contemner, which is taken on record. Copy of such letter has been served to the learned advocate for the applicant. Release this 3 সপ্তাহ পরে date.
My lord, the officer is personally present. My lord, he prays for 4 weeks time. My lord, kindly. 4 weeks.
Started from my end 2 weeks. You said
My lord,
3 weeks. The officer
but-
says
but
4 weeks.
he
What is this happening, sir?
He personally appeared. My lord, kindly. I'm praying.
This 4 weeks time করে দিন তো 4 weeks হলে কবে আসছে 25th September.
Gratefully, Your Lordship.
Most
My lord, I appear for the commission.
Yes.
My lord, the last occasion, I was at page number 84
80.
when your lordship stopped me from further submission. Shall I begin from the same page?
Yes.
Grateful, my lord.
You refer to
Kindly come to page 84, my lord.
para 16 and 17. Yes, last occasion you have referred to para 16 and 17 of the writ petition.
Yes, and annexer at page number 84.
Page number 84. Yes.
My lord, I had spoken about 2 memo numbers. In column number 3 and 4, there is a mentioning of 2 vacancy reports of subjects English Honors PG category and then History Pass category. Both of the same madrasa, Maulana Muhammad Ali High Madrasa. My lord, kindly turn back to page number 72.
Yes.
My lord, this is memo number 201 bracket 20 ME dated 24/4/2008. Written by the Director of Madrasa Education. My lord, I'm reading the relevant portion 1, 2, 3, 4, 5. Fifth line. The government of West Bengal, GO number 94 MD, dated 21/1/2008, has appointed a committee of which Director of Madrasa Education West Bengal is the member secretary to select and recommend suitable candidates for appointment to the post of teachers in those madrasas. So all the vacancies in teaching posts of madrasas should henceforth be sent to the Director of Madrasa Education, West Bengal, Vikas Bhavan, second floor, Salt Lake, Kolkata, 91.
Yes.
My lord, this memo number speaks of 72. Yes, sir. This memo number speaks of the direction given by the Director of Madrasa Education to all the district inspector of schools to send vacancy reports in terms of teaching post to his office. And why this was done? In the earlier occasion, I had clarified that although West Bengal Madrasa Service Commission was formed, but it had not started functioning at that point of time. So, as per this memo number, to be read along with 94 MD, which is in the middle, as per these two memo numbers, the Director of Madrasa Education was empowered to accept all the vacancy reports of teaching posts of madrasas for the purpose of first publication of initial advertisement, then our conduction of all related recruitment processes. Why? Once again, I'm reiterating the same thing. Madrasa Service Commission is not in the picture. Madrasa Service Commission, although it's formed, but it did not come into force at that point of time. So, my lord, kindly come to the two memo numbers, and next that's page number 87 and 88. This is again very relevant in my case. My lord, see from the top, page number 87. This memo number is written from the Secretary Maulana Muhammad Ali High Madrasa and to the Director of Madrasa Education through the District Inspector of Schools. The concerned authority who is providing all these details is the District Inspector of Schools, as per the earlier memo number, which I have spoken earlier. It is not the madrasa. It has reached via madrasa to the direct District Inspector of Schools. And after the post is sanctioned, a memo number is given that I told you, Lordship, earlier on. This is that memo number. Below, my lord, see the memo number left-hand side, 1361/2/M, and date is given. This post is not sanctioned. And the reporting is given to the Director of Madrasa Education and Member Secretary, Committee for Selection of Teachers in Madrasas, Vikas Bhavan, second floor, Salt Lake, Kolkata, 91, and not to the Chairman or Secretary of the West Bengal Madrasa Service Commission.
Okay.
The page number 88, the same thing. This is the vacancy report of history pass of the same madrasa, but memo number is different. 1362/2/M, both dated same date. But on the same date, those two vacancies were sanctioned by the District Inspector of Schools, Kolkata, for the purpose of enlisting those vacancies for second state level selection test 2008 conducted by the West Bengal Madrasa Service Commission.
Now, what is the illegality in this notification? What is the illegality? In 72, you say that this Director of Madrasa Education called for the vacancies. At that point of time, the Service Commission Act was not operative.
Not operating at that time.
So vacancies has been sent to DME.
To DME.
Yes. Now 88 and 87 and 88 are these vacancies being declared by the DI that these are the vacancies. So it is forwarded to the DME. Now what is the illegality in 87 and 88?
Come into that, master. Now, my lord, I have already spoken about that. I participated in the second SLST, and that admit card is annexed as page number 76. My lord, kindly look at it. Page number 76.
Yes.
This is the admit card which was issued to me to participate in the second state level selection test 2008. Now, who is the person responsible? Who has issued this admit card? Committee for Selection of Teachers in Madrasas in West Bengal. This is the provisional admit card. In place of Madrasa Service Commission, this particular director of Madrasa Education is still in charge up to 21/12/2008.
Yes. Yes.
Now, let's come to paragraph number 36 at page number 30. My lord, I'm reading. Your petitioner states that after the formation of the Madrasa Service Commission, all the records, including vacancies relating to the said test, have been forwarded to the office of the West Bengal Madrasa Service Commission by the Director of Madrasa Education, via its memo number 82ME dated 4/2/2009, as informed to your petitioner by the Director of Madrasa Education, via its memo number 346ME dated 27/2/2012, in response to your petitioner's letter dated 7/2/2012. Xerox copy of the letter and memo number annexed. Please come to P23 at page number 130 and 131.
Yes.
My lord, I beg your lordship's pardon, kindly turn one page earlier, 129.
Yes.
This was an RTI application that I wrote to the Director of Madrasa Education, seeking for information. I wrote two questions were asked. Kindly let me know the date on which the Director of Madrasa Education or member secretary on behalf of the Committee for Selection of Teachers in Madrasas forwarded the vacancy reports for the second state level selection test 2008 for English Honors PG category and History Pass of Maulana Muhammad Ali High Madrasa 47/ Dr. Sudhir Basu Road, Kolkata, which were reported to your office by the District Inspector of Schools in its schools in accordance with the notification number such and such. Number two, also let me know the date till which your office has forwarded vacancy reports received by your office by it from the DI, SI, etc. to the office of the West Bengal Madrasa Service Commission for the second state level selection test 2008. This was the relevant information which I had asked from the Director of Madrasa Education. But the noble gentleman refused to provide me the information in its correct form. He instead forwarded the application to the West Bengal Madrasa Service Commission, and thanks to him for providing one particular information which is annexed as page number 131. Kindly come to 131, my lord. My lord, this is memo number 82ME dated 4/2/2009, issued by the Director of Madrasa Education to the Chairman, West Bengal Madrasa Service Commission, Haj House, 26B, Dilkusha Road, Kolkata 17. And what is the topic? Submission of vacancy reports of teaching posts. My lord, got it?
Yes, yes.
My lord, I'm reading further. Sir, in response to the above subject, what is the subject? Submission of vacancy reports of teaching posts. I am sending 19 files containing vacancy reports collected from time to time from the following districts for the purpose of recruitment of teachers in madrasas in West Bengal for taking further action from your end. Why is this gentleman providing all these informations? Why is this gentleman submitting vacancy reports? Because he had collected it. He was empowered to collect all these vacancy reports. And after the coming into force of the West Bengal Madrasa Service Commission, the Director of Madrasa Education has now forwarded all these vacancy reports to the Chairman of West Bengal Madrasa Service Commission. And on which date this was forwarded? This was forwarded on 4/2/2009. Kindly note this particular date. This is extremely important, my lord. My lord, as per Rule 8, Sub-Rule 1 or 2 of the West Bengal Central School Service Commission Rules 2007, which is applicable in the instant case, all vacancy reports which has reached the office of the commission up to 1/1/2009 shall be taken into consideration.
Devendra, कागज है? Yes.
My lord, on the previous occasion, I had showed your lordship Rule 8. The same rule is applicable. I've got the book. If your lordship want, I'm ready to provide. As per Rule 8, Sub-Rule 1, the vacancies need to be reported prior to 1/1/2009.
Yes.
But when these vacancies were reported, these were reported only on 4/2/2009, which comes much after 1/1/2009, the last cut-off date of receiving of vacancies in terms of teaching posts for the second semester 2008. And it contains not 1, 2, but 19 files.
Yes.
My lord, I'm assuming that of these 19 files, kindly see number 19. It must be enveloped, covered up by a file. So all the vacancy reports of Kolkata district must be in it. I had spoken of 2 vacancy reports of Kolkata Madrasa. It must have those 2 vacancy reports in this file. File number 19.
That page number is 87.
Page number 131.
No. That Kolkata vacancy that you have.
Yeah, yes, 87, 88. No, that was at reporting was done.
70 something. 84.
84, man.
84.
And this was informed by the district inspector of schools himself, my lord, that he has submitted those 2 vacancy reports to the Director of Madrasa Education. And it has been stamped at 84, 5th November 2008. Those 2 vacancy reports were received by the Director of Madrasa Education on 5th of November 2008, which comes much before 1/1/2009. the last cut-off date of receiving of any listing of vacancies.
Yes.
So when I asked for information about these two vacancy reports, the Director of Madrasa Education kept war-like silence. He did not respond to my call, to my application, and rather provided me this particular information, which is annexed at page number 131. Thanks to him for providing this information, because this information even is enough to come to a conclusion. So, my lord, as per this particular memo number, not a single vacancy reports in terms of teaching posts for the second university received the office of the chairman or secretary of the West Bengal Madrasa Service Commission prior to 1/1/2009. So, if this is the case with the Madrasa Service Commission, or may I ask a very simple question before your lordship? Will your lordship cancel all those appointments made in the year 2008? Because not a single vacancy reached the office of the commission prior to 1/1/2009. But even that, those two vacancies cannot be rejected, because those two vacancies were sent to the office of Director of Madrasa Education well within time. And lordship will be amazed to, I will come to that point later on, that they have included 1362. The legality your lordship was talking about, one of this legality is that they have included vacancy number 1362/2 of the subject history pass of the same madrasa. Displayed that in the counseling menu, allowed a similarly situated candidate to exercise his option, and got replacement to that particular vacancy way back in 2009. And from that time, I'm suffering for the last 17 years. What is my fault? Why am I being sidelined? No answer. I will come to that. I've become sentimental. I'm sorry, my lord. But this is the case. Shall I move to the next point? They have included 1362 and they have left out 1361. 1362 comes after 1361. And both the vacancies were reported to the Director of Madrasa Education on 5th of November 2008. Why one vacancy was included? Why the other was excluded?
Yes.
My lord, after the most important page, the coming into force of the West Bengal Madrasa Service Commission. My lord, kindly come to page number 10 of my supplementary affidavit.
Yes.
My lord, it's Roman 4, paragraph. My lord, I'm reading. As per information received through the letter of district officer Minority Affairs and Madrasa Education Department, wide memo number 748/46 MAME, dated 4/12/2012, annexing therewith the letter of the chairman and the secretary of West Bengal Madrasa Service Commission, wide memo number MSC 43, dated 12/2/2009, and memo number MSC/51/09, dated 18/2/2009, and memo number 152/16A/MAME, dated 25/3/2009, wherefrom it appears that the chairman of the commission instructed the DIF schools, the district officer, monetary affairs, and madrasa education officer in charge, monetary cell, to submit vacancy reports of teaching posts of madrasas for the second SLST 2008, which occurred up to 1/1/2009, to the office of the commission by 25/2/2009. My lord, I'm making a pause here. I will come back to this relevant page in the latter stage. But before proceeding, kindly have a look at the memo number MSC 43, dated 12/2/2009, annexed as page number 28 of this supplementary affidavit. My lord, at page number 28, this is the letter memo number MSC 43, dated 12/2/2009, written by the chairman of
Page 29.
Sorry, 2009. I beg your lordship's pardon.
No. This is page 29 you are reading?
28.
28. Yes.
From the chairman, West Bengal Madrasa Service Commission, to the DIF schools, Kolkata, / the district officer, minority affairs, and madrasa education, / officer in charge or minority cell. And what is the subject? Submission of vacancy reports and filling up of the vacancies, etc. And reference made, point number 1, the West Bengal Madrasa Service Commission Act 2008. Point number 2, this is relevant part, coming into force of the West Bengal Madrasa Service Commission. This is now their assertion that we have now started functioning. And it has a reference of GO number 1463, earlier one, and selection of teachers in madrasas in West Bengal 2008.
Yes.
My lord, I'm reading. With reference to above, the undersigned likes to inform him that the second test for selection of teachers in madrasas for the post of assistant teachers, headmasters, headmistress, superintendent, and assistant teachers in undergraduate category was held on 21/12/2008, in which I participated, and 11/1/09 for the headmistress or headmaster, I think. As the commission has started functioning, all the existing vacancies up to 1/1/09 in the prescribed form duly filled in may kindly be reported to the West Bengal Madrasa Service Commission, Haj House, 26B, Dilkusha Street, Park Circus, Kolkata 73, after checking for recommendation of suitable candidates. While according prior permission or reporting vacancy, he should look into the existing staff pattern and rationalize and rearrange the same in conformity with the staff pattern if necessary, as and when vacancy occurs. The requirement may not necessarily coincide with the group, subject, or qualification of the incumbent holding the earlier post. He is also requested to submit subject and category undergraduate, past graduate, honors PG wise number of vacancies as on 1/1/2009. This is to be noted, my lord, of teaching posts including headmaster and superintendent separately existing in madrasas, with remarks, if necessary, and individual vacancy in the prescribed format given over leave by 25/2/2009. Now, my lord, Again, another date. This is not my assertion. They have said this is their office memo number, which I have procured from other sources, all through ITA informations. And who has informed me? The Minority Affairs and Madrasa Education Department, Howrah. The earlier page number 27. In response to this RTI application of mine, they have annexed, they have provided me this information, through which it becomes crystal clear that they have themselves stated that vacancies need to be up to 1/1/2009. But if those vacancies be reported to them by 25/2/2009, that will be accepted. So they have himself said this, that up to 25/2/2009, all those vacancies which were reported, which will be reported to them, will be taken into consideration for the second state level selection test 2008.
It says that till 1/1/2009.
1/1/2009 is the cutoff date.
Yes, the reporting will be within 25th February.
25th of February.
It's not that the vacancy till 25th February.
No,
Vacancy
exactly.
will be 1/1/2009, but reported within 25th February.
Within 25/2009.
Yes.
Exactly, my lord. Now, my lord, the same, the next page, page number 29, memo number MSC 51/09 from the Secretary, the West Bengal Madrasa Service Commission, to District Magistrate of etc. And the same subject, submission of vacancy reports in madrasas. This is dated 18 February 2009.
Yes.
My lord, I'm reading. I am instructed to forward herewith a copy of the memo number MSC 43 dated 12/2009. This is the earlier memo, which I have read earlier, by Dr. Anwar Hussain, the then chairman of West Bengal Madrasa Service Commission. The West Bengal Madrasa Service Commission addressed to the district officer minority affairs, minority cells in connection with submission of vacancy reports in madrasas as on 1/1/2009. For the post of assistant teachers, headmaster, headmistress, superintendent, and assistant teachers in undergraduate category, for your kind perusal, and request you to issue instructions to the concerned authorities to submit the desired report within 25/2/2009. The same thing is repeated by the Secretary of the West Bengal Madrasa Service Commission. Now, these two noble gentlemen, the chairman of West Bengal Madrasa Service Commission and the secretary of Madrasa Service Commission, have given the same opinion that vacancies which will reach their office up to 25/2009 will be taken into consideration for the second state level selection test 2009. 8.
ডেট বলো 18 একটু এগিয়ে নিতে হবে ওই দিনেরটা বলে দেবো না এগুলো হচ্ছে না একটু okay
is submitting
fixing on 18 September. You just find out.
But if you not much, I will come the next day. No problem.
18 September.
Okay,
you
Well, the
conclude
next
your
date-
argument on
well,
that.
next date should be the suitable for whatever suits him.
I am free day and night, 24/7.
Not night. We will take it up on day.
So, no, you are doing quite good. So once he finishes, my lord, I may not make my submission on the
Make
very
it-
same day.
Yes.
I will do on the next date. with my
এইখানটা একটু
suitable-
এগিয়ে নেবো তো, হ্যাঁ ওই দিন আর কিছু রাখবেন না 18 September.
Very interesting, and very amazing. And I hope
18
to
September.
convince your lordship
Conclude that.
with the help of my argument.
Okay. Mr. Muhammad Tariq Jamal, the petitioner in person. Due to paucity of time, hearing could not be concluded. This is matter on 18 September. ওটা এখন বলার দরকার নেই, আমরা দেখে নিই 2026.